Well, hey guys, welcome back. Welcome back. I I don't know if you're able to see me here or hopefully hear me, because I might be having a little bit of an issue here with my signal. I'm on Starlink, and I think historically it's been pretty good, but like I'm not really seeing myself on the camera and stuff, so I don't know. Fingers crossed. Hope everything's going okay. So great. If it's just me, then that works fine for me. So here I am. There I am. Hey guys. Oh, tech stuff. It's always so fun. Well, so welcome back. Another beautiful day here down on the south end of the earth. Woke up to a beautiful morning overlooking the Beagle Channel down here. There were some very loud ibises outside my window that were making all kinds of noise. I guess they don't really like people very much. If nobody's out there, they just kind of hang out and are fun to watch. But you go anywhere near them, they start shrieking up a storm at you. But that's not the worst way to wake up by any means. So beautiful day here. If any of you besides Jeff are joining me from home on the West Coast, thank you. Sorry I had to push this up a little bit, but I got to get into town a little bit later today, and I'm going to have to walk, and it's a little bit of a longer walk than I thought it was going to be. It's about 7 kilometers. So it's going to take me a little bit of time, and I needed to make sure I had enough time to get through our hearing today and still be able to make it in. So I guess we got an evidentiary hearing. I didn't honestly know we were going to have an evidentiary hearing on the motion to suppress. I kind of thought it would just be argument because at least from the briefing that we were able to see, most of it seemed to be pretty straightforward legal issues. Things with overbreadth and stuff like that. Now, again, there was some overlap, of course, with the IGG and Franks and so forth. But I'm not entirely sure what to expect here in terms of what evidence is actually going to be being taken. So I don't know. Guess we'll see. So with that, I got us all queued up, and let's go ahead and get this live stream going.
Your Honor, first,
hang on a second.
oh, sorry.
Haven't called us to order
Oh,
yet.
I am so sorry. I thought you said, sorry.
I said, let's bring the public in.
Okay.
I appreciate the eagerness, though. All right, are we broadcasting, Sandra? All right, this is
check my playback.
continued hearing.
I'm going to turn it up.
The Kohberger CR 0124316665. Defendant is again present with counsel Ms. Taylor and Ms. Massoff. The state is present, represented by Mr. Thompson, Mr. Nye, and Ms. Jennings. This morning's hearing will discuss the motions to suppress and any evidence related thereto, as well as we'll get into the argument on that. So with that, I understand the parties are prepared to proceed. The defense, do you have witnesses to call this morning?
We do, Your Honor. We have two.
All right, who's your first witness?
Corporal Brett Payne.
All right.
Payne, Corporal Brett Payne.
Payne would step forward.
The author of the warrant affidavits.
You were sworn yesterday, as I recall, but we'll go ahead and do it again just for formality's sake.
Good morning. Could you please state your name and spell your last for the record?
Brett Payne, last is spelled Payne.
And what's your title?
I'm the detective corporal for Moscow Police Department.
Can you tell the court, I know you testified yesterday, but it was a different hearing, and so just to lay a little bit of foundation, can you tell the court your background in law enforcement?
So I've been with Moscow Police Department for almost 7 years now. Prior to that, I was in the active duty military for 6. 3 of those were as a commissioned officer in the military police corps.
So I vaguely remember this guy from one of the previous hearings. I think probably the motion to compel with the IGG. And if I remember correctly, You guys can correct me in the chat if I'm wrong, but for the search warrant, the author of the search warrant, he just sort of deferred to everybody else. It was like talk to everybody else about I don't know anything. I just got the information from the other people. Was that this guy? Pretty sure that was this guy. So I don't know if I'll need to take a lot of notes. Hopefully I won't, because I don't have a ton of paper. I didn't bring all that much down here. I do have some like scratch stuff I'll be able to use, but we'll see. So, you know, if his memory isn't any better than it was before, I guess I may not need to take notes of an awful lot.
What is your role in this case?
I was assigned lead detective in this particular investigation.
And so as lead detective, can you explain from your perspective what that has meant that you have done?
Certainly. So it was my responsibility to basically view this investigation from a 30,000-foot view, if you will. Directly, it's the teams that were assigned to various tasks, and then taking all that information, synthesize it, put it back to our group, and then eventually consolidate it into an affidavit.
And in terms of that affidavit, yesterday there was some discussion and testimony about that and how it was created. Would you explain that?
Absolutely. So the information was brought to us via various teams and specialists in their particular areas. For instance, most of the cell phone stuff was covered by
I moved myself so we can see the judge.
All that information was brought to the team, relayed back out at least twice a day, and then as that information was essentially synthesized, it was put into a running document, a living document that is now known as Exhibit A.
So when it was characterized yesterday as a group effort, do you agree with that characterization of it?
Yes, ma'am.
And do you know approximately how many warrants you worked on in this case?
I don't, ma'am. Several. I don't know the exact number.
Right. I'm going to walk you through several segments of different warrants, and some of this may seem choppy, but I'm going to try to do you and then Detective Mowery at once instead of bringing you back and forth. Does that make sense?
Yes, ma'am. Sounds good.
All right. And Judge, I have paper exhibits for you and for the witness. And so I'll go as fast as I can, but I want you to be able to look at what he's looking at. So we're going to begin with the first AT&T warrant. Prior to this case, had you ever secured an AT&T warrant?
No, ma'am. I don't believe I had.
And so given that, who did you rely on in creating the warrant? For
Largely
AT&T?
Special Agent Balance. Obviously, he's the CAS expert, so I relied heavily on his input.
At the time that AT&T warrant 1 was secured, were you co-located with Special Agent Balance?
I believe so, yes.
Can you, well, in terms of being more specific, it was December 23rd. Were you two co-located at that time?
I believe so, yes.
And I know co-located has been talked about in court a couple of times, but can you just explain what it means for you two to be co-located since he's from DC?
Certainly. Yeah, he was in the same building as I was, just mere feet away from the command post.
Okay, so when you say mere feet away, were you guys in like a cubicle setting, or were you in offices with doors? What was this setting in terms of proximity to each other a few feet away?
Yeah, separate offices with doors, but in the same second floor of the Moscow Police Department.
Are you aware of Special Agent Balance in his work in doing AT&T records, having any access to AT&T records without a warrant?
I'm not aware of that, no.
Are you aware of him having any ability to review AT&T records through any portal without a warrant?
Not to my knowledge, no.
I'm going to begin with what is known as State's Exhibit 1 attached to their objection to the motion to suppress AT&T warrant. And Judge, for today's purposes, what I'm doing is relying on the labels that are in the record as opposed to giving them new stickers.
This has been marked previously as State's S1, or is that 8-1?
I think it's SS for State 1.
All right, State's S1 affidavit for search warrant.
No, I've got to get.
Objection to the admission of that for today's hearing.
You know, Judge, I should have started out by saying that the same stipulation regarding the admission of all exhibits applies today.
We do need the formality of moving for the admission. So
I can do that. Do you want me to do that per exhibit?
Well, it makes, as you're talking about them, it probably makes sense.
Okay, I've got to get myself S1.
I don't know why we're going to make them formally move for admission if we're stipulating everything is admissible. But some people are sticklers about some details.
Okay, Detective Payne, can you look at page 5?
Ma'am.
On page 5, can you read what it says in the at the very end of the page in the sentence above wherefore that begins with the paragraph? It begins in support. Can you read that paragraph?
Certainly. In support of the assertion as to the existence of probable cause, the following facts are offered based upon personal knowledge of affiant. See attached statement of Brett Payne, which is marked Exhibit A and incorporated as though fully set forth herein.
And is that S1 the affidavit in support of the search warrant?
Yes, it is.
And that's the AT&T 1 search warrant that was the first one served on December 23rd, correct?
That's correct.
And that language that you put in there, Exhibit A, is incorporated as though fully set forth herein. Is that the language you just read?
Yes, ma'am.
All right, I'm now going to hand you State's Exhibit 2 to the AT&T first warrant.
So I'm seeing maybe a
Can you
little bit
review
of
that first page, the first paragraph.
an issue here with the personal knowledge declaration. You know, it's not obviously his personal knowledge. I don't know if that's where the defense is going to go with it. They've kind of hinted at that before. Like if you're going to claim personal knowledge,
S2.
Pardon?
Are you seeking the admission of S2?
I am seeking the admission of S2. Just to be clear, Judge, all of these that I'm putting before him and the ones that are attached, we're seeking the admission of.
Objection to S2. All right. submitted.
then
Have you reviewed that, Detective Payne?
you get the downside
Do
too.
you see that the language that I just referred to in the search warrant affidavit? Do you see that same language in this warrant where you incorporate the affidavit, incorporate Exhibit A into your? You see that language
Ma'am.
in S2, and is S2 the actual search warrant for AT&T?
Yes, ma'am, it is.
Can you turn to the last page on page 4? What time was the warrant served?
10:03 a.m.
Do you recall that the return on that warrant came in at 3:30 that day?
That would sound correct. I don't remember specifically.
Would it help if I showed you the AT&T mobility propriety front page to verify?
Yes, ma'am.
Judge, I'm not seeking the admission of this, just for purposes of him being able to be certain. Sorry.
To
This may
refresh.
be showing the document to refresh his recollection.
Yes, Your Honor. And Judge, for the record, this has also been admitted already in Frank's D17, page 634. Detective, can you see on that that came in at, I think it's 15:30? It's
15:31.
okay. Thank you. I'm now handing you Defense Exhibit A to the reply to the AT&T suppression motion.
So it took 5.5 hours to get the information
This doesn't have a sticker
and
on
file
it.
the return.
This does not. You have a sticker on it.
No, it is not, but it is attached to the reply as Exhibit A, AT&T. And that reply is. Okay. Can you see line 4 there? Oh, sorry, Judge.
Copy and put, let's just you have a number that we were going to call this?
I would call it Exhibit A to reply, because that's what it is in the record. You see at the bottom of the page where it says Exhibit A, AT&T.
So this is the return of the warrant of S2.
Yes.
All right, let's call it S2.2 or 2.1, pardon me.
That's fine.
The fact that it's associated with that particular warrant.
Nothing like making up exhibit designations on the fly. That never goes awry. Clerks love it. The public loves it. The press loves it.
Detective Payne, on page 2 of that Exhibit A, it's actually just the front page where it says Affidavit of Brett Payne. What does paragraph 4 say?
Paragraph 4 or line 4?
Line, well, 1, 2. Line 4.
It says the warrant was served on 12/23/2022 by email, fax, etc.
So do you know, does it say anything? On the next page, the receipt and inventory of warrant, do you see that?
Yes, ma'am.
Can you look at description of property? What does that say?
So this, I think, is pretty clearly getting at the overbreadth issue, right? This was the argument that had come up because these warrants were pretty all-encompassing. And so the state will always argue, well, it's limited by the affidavit. There's case law that allows you to infer that even if the language of a warrant is really broad, if the affidavit itself didn't ask for, necessarily quite as broad as the plain language of the warrant itself seems to call for, then you can just go ahead and like infer that that the warrant had been narrowed. But that's only if the affidavit has been incorporated into the warrant. And so that's why she's asking questions about it being served with the warrant, because would AT&T know, here's what the warrant says you want, but then if I go and I read through the affidavit and I understand exactly, what the context is and what you're trying to achieve with it and so forth, then I can be a little bit more specific and targeted in trying to answer your inquiry. But if they didn't have the warrant, they can't do that, or they didn't have the affidavit, they can't do that. They're going to just rely on the plain language of the warrant. So let's see what they actually got.
509-592-8458.
Can you explain how that's a description of property and what that means?
It just means essentially that there was the information retrieved as a result of that phone number being queried with AT&T.
And it
So
indicates that
he's saying
that was produced how?
they got a number.
Entrance was obtained by email.
And when that was received, did you do anything to verify that the data was within the date ranges of November 12th to November 14th of 2022?
I don't remember. That information was provided to Special Agent Balance as soon as it was received.
Do you have, when you say that it was provided to Special Agent Balance, is that because you don't have the capacity, technical skills, I guess, to review that raw data and do something with it?
Yes, ma'am.
So I remember this before from the cat. I think it was the cast stuff. Was it the cast stuff before where he testified? He's just everything was balanced. Everything's the FBI. He doesn't know anything about anything. I was thinking that was Mowery though, but Payne seems to be following the same line here, throwing balance under the bus, and so a little bit more of a clue maybe about why the FBI hasn't necessarily been all that cooperative in this case.
Was there anybody else that you relied on for that other than Special Agent Balance?
Not that memory brings to mind.
Let's now turn to the AT&T 2 pen trap and also known as pen trap and trace. Can you explain what a pen trap and trace is?
So pen register, best of my knowledge, now granted, I am, as I've stated before, I'm not an expert in cell phone stuff, but best of my knowledge, a pen register tracks incoming and outgoing phone calls, text messages, so on and so forth. And then the trap and trace is the portion that essentially gives you location data, or the precision location data rather. So it's essentially incoming and outgoing calls. what messages are received, and then part of that was where that phone was located.
Was it required that you secure the AT&T first warrant to obtain the second warrant that included a pin, drop, and trace?
I don't believe it was required.
So when the data was received on at 3:30, you gave that data was given to Special Agent Balance?
Yes, ma'am.
Okay. And then what happened in between 3:30 and 4:53 when the second warrant was secured?
Are you talking technically speaking, or can I speak in generalities? Because that's all I really know.
Well, I want you to talk about what you know.
So the only thing I know is that that information was provided to Special Agent Balance. He utilized whatever tools he has at his disposal, and then it was decided upon to go after the second pin, trap, and trace.
When did you start drafting that second trap and trace?
I don't remember.
So on that day, you did one in the morning that was secured at 10:03.
Yes, ma'am.
And then the second one was secured at 4:53 p.m. And you don't have a recollection of when you were working on those?
I don't remember. No.
All right. I think you have State's Exhibit 2 in front of you.
Yes, ma'am.
Can you flip back to that one? Can you see on page 1, what does it say that the time of that warrant was obtained?
Talking about State's Exhibit 2.
This was the 10:30 or so.
10:03 is what it says. Is that what you're referring to?
No, I'm referring to the return, which should be
Of the
I
return.
might be referring you to the wrong exhibit.
One, I believe.
1531.
And that was at 4:53. The second warrant was obtained at 4:53.
Okay.
I might not have handed you pin trap.
I don't think I have that one.
I'm confused too. So they got that next return like an hour after they asked.
Yeah, my understanding
even
is,
that
just so we're
much?
clear, because I'm getting a little confused, is that we have the affidavit for warrant.
We all
the
are, Judge.
Warrant and the return of the warrant all related to the first warrant to AT&T. And we haven't got the pin, trap, and trace warrant presented yet, I don't think.
Right, I've got it here. And Judge, for clarification purposes too, today as we're going through testimony, my plan was not to go through every single warrant that we're arguing about and get it in front of the court. I'm really trying to take kind of a scalpel approach on the issues that we want to point out to the court. So it does really feel like I'm jumping around, and I realize that. I hope to bring it all together in the end.
We hope so too, because it's
Only
confusing.
caveat being what I've told you before is
Jump
where you
around.
have is a broad array of documentation that you've presented. The court will not scour the record to find support for your motions that's not pointed out to the court specifically. And that's well established with case law in Idaho Supreme Court.
And Judge, that's why I am trying to grab the pieces and parts that I want you to be able to identify, and that's why I'm putting the paper in front of you. So I'm hearing you when you've asked us to do that. All right, I'm handing you State's Exhibit 1. And this is to the second AT&T warrant, also known as pin, trap, and trace.
This one is also listed as S1 on the sticker. So that's going to cause some problem, I suppose.
It's
Yes, Judge.
S1 attached to a different motion to suppress.
Yay! On the fly exhibit naming
Well,
conventions.
hopefully we can figure it out when we're looking at the entire record.
And what I think, Judge, when you are going back and working with your clerk,
My concern, frankly, I know what all the documents are and what they relate to.
Yeah.
My concern is a reviewing court's ability to understand what you're talking about in court today and trace it.
Well,
to
Judge,
these
then just order them in order.
That's my
1,
concern.
2, 3, 4, as she hands them up.
and I understand that. And
That's
so
pretty
in preparation
easy.
for today, I mean, I really did think, do I need to go through and read and label all of these? And I thought that would create more confusion in the record because these are all attached to specific motions with these labels.
It does get confusing, and that is a little bit annoying. And so yes, as somebody who has to deal with this regularly on appeal, I would rather have a set that's attached to the motions and have a set that's separately admitted as exhibits. it's fine because I can cite to either of those. It's in the record. They need to put all of this paperwork in to be able to make the record. That's why he's buried in it. And that's why he's annoyed about, I'm not going to go scour through everything to find the support for your argument. No, but they still need to have it in there because they just need to make sure that all of the bases are covered and all the relevant facts are in, and so on and so forth. It's not necessarily going to be the focus of what they're arguing about today. So that's why she's narrowing it with these other exhibits. That's fine. Make it easy. I would so much rather have, you know, a separate set of documentation like that than I would like to have a long ass transcript full of jumbling arguments about what we're going to call the exhibits and why. Just go ahead and make it easy and get on with it.
This is marked S1, titled Affidavit for Search Warrant and Application for an Order for Pen Register or a Trap and Trace Device.
Yes.
So on the record, what we're looking at.
So Detective Payne, is that the warrant that, that affidavit in support of the search warrant that you drafted for that second AT&T warrant?
Yes, ma'am.
On page 11, at the bottom of the page, can you read that last sentence under probable cause?
Certainly. In support of the assertion as to the existence of probable cause, the following facts are offered based upon personal knowledge of the affiant. See attached statement of Brett Payne, which is marked Exhibit A and incorporated as though fully set forth herein.
All right, I am now handing you S2, which is the search warrant and order authorizing installation and or use of pen register trap and trace device and non-disclosure order pursuant to Idaho Code 18-6772. Can you please turn to page 7? Can you see what time that was obtained?
4:53 p.m.
And when did we get the return? Let's get that next. Let's just be systematic and get it in order. Hey, CH, this is in fact one of my Sharpie gels from Delphi. Thank you so much for asking. I have a backup Sharpie
I'm
gel
now
from
handing
Delphi
you
as
what
well.
is titled Return of Search Warrant, Exhibit A to Trap and Trace.
Does that have a sticker on it?
Pardon?
Does that have a sticker on it?
No, it does not.
It's 2.2.
What do you call that, Judge?
S-2.2,
S-2.2.
further delineated by the title, which is related to the pen trap and trace.
On page, can you look at page 2? You see the top, who does it say it's the affidavit of?
Corporal Brett Payne.
Are you looking at Exhibit A, page 2?
Oh, correction. I see what you mean. Affidavit of Lawrence Mowery is what it says at the top.
Right, and then, but is that actually your
It is. Yes, ma'am.
affidavit? And so that was a mistake.
Yes, ma'am.
I'm sorry, what were you looking at?
On page 2, the top of it says affidavit of Lawrence Mowery.
Oh, gotcha.
It's the affidavit of Corporal Payne.
A heading problem there.
It sounds like it's an affidavit of all of them, isn't it? This is the group project that they all know everything except for the bad stuff. The bad stuff they don't know, only the individual. That's all balance. Only balance knows the bad stuff.
I'm now handing you Exhibit C to the reply to Trap and Trace. It does not have a sticker. and it says AT&T Mobility Carrier Request Warrant.
This again relates to the trap and trace warrant.
It does.
Let's mark that S2.3.
You know, Meg,
In the next day or so, if you would provide a formal identification list, if you will, of the exhibits that you'd stipulated to admission to yesterday, as I don't think we went through those individually, just so that there's a record of that.
We can do that.
Meg, just real quickly, I actually have one, and thank you so much for reminding me because I forgot when I got my new phone. It's got a stylus, so I could do note taking on that if I run out of paper. Thank you so much for the reminder.
Might take us a couple of days, but we can do that. Can you look at, are you looking at that Exhibit C, Detective? Was cell site location data requested for this warrant on this page?
Yes, ma'am.
And was a timing advance report requested on this page? I'll refer you to the last paragraph where it says remark special instructions.
Yes, ma'am.
And do you see any reference in this document indicating that the affidavit in support of search warrant was included with the warrant?
No, ma'am.
So again, no narrowing.
Okay, the next warrant I talk about is Apple.
Apple was the big one, like his entire Apple history forever. It went back to like 2017. This one was massive. If there is if this warrant is not overbroad, then there's no such thing as an overbroad warrant. I mean, they literally asked for everything in his account. And as far as we can tell, they got it.
Prior to this case, had you ever prepared an Apple warrant?
I don't remember.
You don't
What was your
remember?
training related to Apple warrants in December of 2022?
I had no official training at that time.
I'm handing you what's been marked as Defendant's Exhibit A. It does have a sticker, and it's to the Apple motion.
So what's the judge going to call this one? I don't know.
Can you state what that document is?
It appears to be a preservation request.
And who is it sent to?
Apple Corporate Legal Counsel,
And what's its date? What is it? What is the date on it?
December 21st.
Of 2022.
Correct.
And that letter was not sent by you, right?
No, I do not remember sending this. No,
Well, can you look at the
that's not me.
yeah, the top of it is Department of Justice, and the back page 2 is Special Agent in Charge Dennis Rice.
Correct.
How was the DeSales email account known at that date?
I don't remember.
Don't remember. He sure doesn't remember a lot.
How did you become aware of an Apple product in this case?
Memory serves, when the search warrant in Pennsylvania was executed, there was an iPad that was located in one of the shared living spaces in the home. And there's a receipt in his vehicle, in Mr. Kohberger's vehicle, that was found for an iPad as well.
And during the home search, was the iPad seized?
It was not.
Why not?
It was in a shared living space.
Do you remember what day that the Apple account was created?
I don't remember. No, ma'am.
Does 2016 sound familiar with the research?
That sounds vaguely familiar. Yep.
And you mentioned the receipt that was found in his car. Do you recall the date that indicated that an Apple product was purchased?
I do not remember.
Right. I will show you.
I'll show
State's
you.
Exhibit
There you go.
1
I like Miss Masseth. She's on the ball.
to the affidavit for search warrant. And I believe it's tabbed, the receipt.
This is State's Exhibit S1 affidavit for search warrant to Apple Inc.
And it's 2018, the date.
Yes, ma'am.
2018 is the date.
Where did you get the form to prepare the Apple warrant?
A form, be more specific.
Correct. Well, the search, so you're looking at the search warrant affidavit, and inside of that affidavit is a long list of items that you request.
Yes, ma'am.
Where did you get that information to be able to include that?
That was all provided to me from the experts in that particular field.
I'm just getting S1 in front of myself for a minute here, Judge, so I don't, or I'm gonna have to give them a different exhibit.
Just so I'm clear, are those when you said the long list, are you referring to paragraph B on page 2?
On page 2, beginning on page 2,
Is that what you're referring to?
I'm referring to everything A through I.
I'm sorry, was there a question pending? I kind of threw us down a side alley there, so I apologize if there was a question pending that I threw you off from.
No, that's fine. I'm looking for the page here. Do you recall that in your affidavit, there's reference that iOS devices can use an iCloud account to back up the iOS device?
Yes, ma'am. That sounds familiar.
And what is it? What's your understanding when an iOS device uses an iCloud to back it up?
Similar to Google and many other of these digital operating systems, essentially they back it up to a cloud account. That information is stored not on your device only, but also in a cloud storage area. That's my understanding of it.
And so in an Apple phone, that ends up as creating a duplication of what's on the phone.
Essentially, yes.
Essentially, yes.
And do you recall that in the affidavit, you made reference to the fact that Apple users get 5 gigabytes typically of storage and then can purchase more?
Yes, ma'am.
I'm handing you what's been marked as Exhibit D to, it's Defendant's Exhibit D to the Apple memorandum in support of suppression, and it is it does have a sticker.
All right, it's marked Defendant's Exhibit D, date 11/14/24, entitled Affidavit for Search Warrant directed to Apple Inc.
Can you please turn to page 27?
Page 27 of an affidavit. This is definitely getting bigger.
The actual warrant itself that you're.
Yes.
Yes, ma'am.
Well, it's, I don't want to answer that as a yes before I look and make sure what this exhibit is.
I want to make sure because my page numbers run out at 25.
It's Exhibit A, and it's to the Apple warrant It says, so Exhibit D, Apple, at the bottom, that page says page 27, but above that, it says page 23.
I'm there.
Okay. At the top, it says on January 27th, Apple Inc.'s Privacy and Law Enforcement Compliance Office responded with the requested records.
I'm not there. So can you
Oh, I'm
give me some
sorry.
direction? Are we looking at state
Exhibit D,
D?
yeah, page 27 of the, of my marking date. So it says Exhibit D, Apple page 27.
On January 27, 2023.
Yes.
All right, go
Yes.
ahead.
Oh, I already pity
On
appellate
January
counsel.
27th, 2023, Apple Inc.'s Privacy and Law Enforcement Compliance Office responded with the requested records. Can you explain what Apple responded to?
I don't remember what all they responded to. They responded to the search warrant and all those listed items that were in the warrant itself.
And the warrant, the date on this, if you will turn to, let's see. Turn to page 34 of the exhibit. Do you see the date of the warrant?
1st of August.
So I understand that you just said you don't know or you don't remember, but in this context, in your search warrant affidavit, you make reference to something being produced on January 27th to process to get a warrant in on August 1st. Do you know what the process was that Apple responded to or what they produced?
I do not remember. No, ma'am.
So something warrantless? No wonder he doesn't remember.
I'm handing you Defendant's Exhibit B to the Apple Defendant's Memorandum in Support. It does have a sticker on it.
All right, the exhibit, just for the record, is Defendant's Exhibit B, date 11/14/24 on the sticker, and the title is Certification of Apple Inc. Custodian of Records.
Detective Payne, on this, there's a certification. This document is a certification of Apple Inc. Custodian of Records. Do you see that?
Yes, ma'am.
And it indicates that records are certified and being produced from legal process served on to Apple on January 12th, 2023.
ma'am.
You see that? What was served as legal process on Apple on January 12th, 2023?
I don't remember.
You don't know? You don't have a record of serving something? Was it the FBI
What the legal
again?
process would be?
I don't remember what that would have been.
Going back to Exhibit D. Do you have?
I just got to pause this for a second because that's really a problem because that's indicating one of a couple possibilities. So normally in an investigation, the lead detective is the one who does all the warrants, and you basically just do that for organization purposes to be able to keep track of what's going on. Because if you have, everybody who knows how to write a warrant, who's got hands on your investigation out writing their own warrants, that's a mess. And a detective isn't going to want that. It's their case. Warrants can be very technical. If some rando is doing something that messes it all up, that would be very bad. So the detective in charge is the one who does all the warrants. If you're an investigator, you want something, you go to the detective and get him to do the warrant. So that's what I would expect the situation to be. And if that is the case, then there would be some record that he can go back and refer to about what was served on Apple on January 12th of 2023 should have been produced in discovery, some kind of legal process relating to the acquisition of evidence. So the defense should have it. And if the defense had it, I don't think they would be asking this question. So I don't like that at all, that he doesn't know or doesn't remember. what was served on Apple on January 12th of 2023, that's not acceptable.
Have that one in front of you still.
Yes, ma'am.
Can you turn to page 35 of that? On line 4, what does it say?
Warrant was served by Corporal Payne on August 1st, 2023 via law enforcement at apple.com.
And so that would have been the Apple warrant, right?
Correct.
And you served it, right?
I believe so.
Well, when you say you believe so, would you have
Believe
executed
so.
an affidavit if you hadn't?
No, ma'am,
Thank
I just
you.
want to make sure on the warrant return itself that it wasn't served by one of the digital forensics folks.
This affidavit is your affidavit, and on line 4 it says you served it, right?
Uh-huh.
ma'am.
Uh-huh.
Did you serve that with a copy of the search warrant affidavit?
No, ma'am.
This one he knows. So no narrowing. Narrowing is off the table with Apple, and that's a
Was it your
big
practice
problem.
in serving all of these warrants that where you actually did service, that you would serve the warrant only?
Yes, ma'am.
Not helpful to the state there.
And then on Exhibit D, page 37.
Okay.
At the bottom where it says description of property, can you explain what the return was for that Apple warrant?
All account information associated data for the following Apple identifiers. And it goes through DSID, Apple ID v. Kohberger at spartan.northampton.edu, another DSID and Apple ID Wi-Fi Army owns at yahoo.com.
Did you open up the Apple data and examine that?
I don't remember if I looked at what the return, like all
You
the
don't
files that were
remember.
attached were.
So how'd you do a return if you don't even know what you got? I mean, how did you know what you got to be able to do a return? Now I could see it if it was something like, what's the return? The return is, a thumb drive, or the return is an email. But you said the return was associated account information for all of these various accounts and identifiers. So how did you know? How did you know that that's what you got if you didn't look at it?
In terms of evaluating that Apple data, as the lead investigator, who have you put in charge of evaluating Apple data?
I relied on the specialists in those fields, which would be Detective Mowery and then SA Balance. Those are the folks who knew far more about it than me.
Mowery and
Do
Balance.
you know, as we sit here today, whose job it is to evaluate the Apple data for this case?
I don't know, ma'am. Not right now.
Okay, the next warrant we will talk about is Google.
Another broad one.
I'm handing you what's being marked as Defendants D to the Google memorandum in support of suppression.
Right, so that I'm clear and the record's clear, this is Defendant's Exhibit number D with the date on the sticker of 11/14/24, which refers to the sticker date, I believe, not necessarily the document date. And then it's entitled Return of Search Warrant, the warrant being with respect to the application of search warrant for Google LLC.
Okay, so it's the Google return. I just saw a comment fly by in the chat that I just wanted to show. I just wanted to pull this up because I think it is a very important question and I have some thoughts about it. Why is there so much shade around cases of late? Make it make sense, someone. The answer is that there has always been this much shade around cases. We are just seeing more and more of it because cases in general are getting more attention. There's more of them being televised. There's more interest in true crime. There's more focus on the process. And so this now isn't just a dirty little secret that defense attorneys talk about in their conferences and nobody else is aware of. It's always been like this. It's always been shady like this. All right, we'll continue.
That as the other documents that were proper are admitted.
Did you prepare the Google warrant returns Exhibit D?
Yes, ma'am.
On page 2 of that exhibit, does your affidavit say Detective Mowery served the warrant through a portal?
Yes, ma'am.
How did you know that?
Told me that.
When did you get the return? When you got the return, did you review the data?
I did not, ma'am.
Did you take any steps to see if the return conformed to the warrant?
I did not look at the technical data contained within. I believe it was a zip file that was downloaded from Google, if memory serves me correctly. I downloaded it and made sure that that was there.
And do you recall that there were actually 3 Google warrants? Does that sound familiar? I'm going to hand you now Defendant's Exhibit E. The Defendant's Exhibit E to Google memorandum in support of motion to suppress.
All right, defendant's exhibit number E, again with the date on the sticker 11/14/24. This is a receipt and inventory of warrant to Google.
On this document under the description of property, can you state what Google account you put in as received?
Zip files for all digital records for the Google accounts of Bryan Christopher at gmail.com and username spelled a bit different at gmail.com.
Did you know that the email in the warrant is actually Bryan Christopher 1994 at gmail.com?
Oh, that sounds familiar. Yes, ma'am.
So on that description, is that a mistake?
Yes, ma'am.
And did you do anything to, I asked you this, but you didn't do anything to verify that the data that you received from Google fit what was requested in the warrant?
No, ma'am. Not my recollection.
That's it for Google. You were in Pennsylvania for Mr. Kohberger's arrest, correct?
Yes, ma'am.
And you watched the preparation for service of the arrest warrant?
How do you mean?
Well, maybe I should ask this more open-ended. Tell us about your arrival in Pennsylvania in time-wise to his arrest, time frame of his arrest.
I believe we arrived there, if memory serves, about 7 p.m. on the 29th. And I think I get my dates right here. We observed final preparations for the SRT operation that was going to take place. And then we being myself and Detective Gilbertson from ISP, drove to a separate Pennsylvania State Police barracks to await the arrival of Mr. Kohberger.
When you were observing preparations, what were you observing?
I believe we observed their final tactical brief for SRT, and that was about it.
Did you observe anybody putting on a body cam? Just curious.
Can you explain what that was, what the preparations were that they were making when they were doing that tactical brief?
I can give you a general overview as best I got. So they had their entire SRT that was going to be conducting the operation present.
For the record, SRT is
A special response team, usually what it stands for, Your Honor. So they were doing their final preparations, going over their approach, team member assignments, so on and so forth. This was all done via basically a briefing in front of everybody.
And do you recall that the preparations included that in preparation they were going to knock and announce in execution
I believe that was brought up. Yes, ma'am.
of the warrant? Okay. And while you were there, did you go into and have were you given a tour, or did you drive into the gated community of Mr. Kohberger and see where he was living?
No, ma'am.
You never went in or around his home?
No, ma'am.
When the execution of the arrest was happening, did you have the ability to listen in any way?
The only ability that we had at the time was a very choppy drone feed. We were driving at the time it happened, and that was the only
A drone feed.
And so how was that choppy drone feed being communicated to you?
via cell phone.
So can you explain that? Like, who's the person communicating with you? about the drone? I just don't understand.
So essentially, it's a drone operator with their SRT. I don't remember how it was conveyed, a link of some sort. They dropped a drone, it took off. I got the link so we could essentially just watch a live feed of what the drone was seeing. And that was it.
Do you know if that live feed was recorded?
I do not know, ma'am.
Did you record the while that was happening? Did you create a recording?
Oh, ma'am.
What is a Bearcat?
Bearcat's an armored vehicle.
A Bearcat?
SWAT operations.
A Bearcat? What's a Bearcat? Did they use a freaking Bearcat? Oh my God, this is one of those military, things when the police get all excited because it's like military surplus and they give it away because the army doesn't want to have to pay to maintain it and stuff anymore. So they give it to these local law enforcement agencies, and most of the time you just they use it for like going around in parades and stuff, because what practical use do you really have for a freaking Bearcat? I don't know if I want to hear what they did with the Bearcat. Let's go.
And do you know what role the Bearcat? Describe that vehicle again.
So they're usually built on, I think it's like a Ford F-250 chassis. So it's a pickup cab essentially, but it's got a large box compartment in the back, for lack of a better term. Usually has portholes on the sides. It's highly up armored to protect the occupants, being SWAT operators. And they usually use them as an approach vehicle. So they have a covered location to deploy from.
Is it a like a retrofitted military piece of machinery?
No, ma'am.
It's specifically a law enforcement piece of machinery.
Yes, ma'am.
No, I stand corrected. This one is specifically for law enforcement. So they can have a covered approach to a quiet residential house at, what was it, 2 a.m. or whatever. Oh man. Pardon me if I'm a little intolerant of the drama with this stuff, but I just had a case in Washington with a little drama over officer safety considerations. And now, granted, I understand, yes, safety is a big consideration. Lots of interactions are very dangerous. Officers are not required to put their life, well, I mean, they sort of are putting their lives on the line, but they're not required to take unnecessary risks in order to do their jobs. But having said that, they can really be some major crybabies about safety, and particularly in situations where they have the ability to control the circumstances and to minimize the risks to themselves. They just have this tendency to act like they're helpless. So sorry, that's just a little bit of a soft spot for me right now, which is why this Bearcat is kind of hitting me the wrong way.
And it sounds like it's really big.
It depends on what you're comparing it to. I'd say it's no bigger than if you were to have a pickup camper on the back of an F-250, something like that.
And what's your understanding of where that Bearcat was parked for the arrest?
I believe the Bearcat, if memory serves, drove up the driveway and just parked in front of the house.
I'm handing you what's been marked as State's Exhibit 5 to the motion to suppress.
Also, I'm just going to say, why does he know more about a Bearcat than he knows about what he sent to Apple? Priorities? Just asking.
And it was attached to 119 Lambsden.
All right, this is marked with an exhibit sticker S5. Title of the document is Pennsylvania State Police. Heading with essentially a letter directed to Detective Payne.
Detective Payne, can you explain what that letter is?
That's a justification for reasoning for amending the original plan for knock and announce to a hasty knock and announce and quicker entry into the Kohberger home.
Hasty knock and announce.
When did you receive that?
believe this was recently. I don't remember what date.
When you say recently, was it received in response to prepare for today's suppression hearing?
I believe so.
Do you know why Mr. Lang didn't date the letter?
So they revised their plan from knock and announce that he sat in on the briefing on at some unspecified point because apparently they didn't really knock and announce. And they sent a letter after the fact. This is a CYA letter. That's all this is. This is a CYA letter.
I have to ask him, ma'am.
And so in that correspondence, he explains that the knock and announce was shortened to announcing from the Bearcat with immediate forced entry.
Yes, ma'am.
Were you present when Detective Gilbert Mirandized Mr. Kohberger at the station?
Detective Gilbertson?
Gilbertson, sorry, yes.
Yes, ma'am.
And that took place after Mr. Kohberger was first seized in his home, right?
Correct.
That also took place after he was transported in the back of a police car to the station, right? You noted in your report that Detective Gilbertson had a recorder in his pocket at the time of the interview.
I believe so.
Were there any recordings that took place at the Kohberger home when entry was made into the house?
I do not know.
Another thing he doesn't know. I'd like to see this explored a little bit more. You don't know about any recordings, so you were aware that there was a drone. You were present at the briefing. You saw who was there, how many agencies were involved. Did you see if any of them had body cams? Did you see the patrol cars? Patrol cars usually have cameras on them as well, don't they? And just make a good record of what type of stuff is potentially available to be making the recording. So it doesn't sound like, oh, there's just nobody happened to bring something. These guys got cameras everywhere. And that's before you even get to the phones in their pockets.
Where was Mr. Kohberger's car parked at the time of his arrest?
It was in the garage.
Was it later seized pursuant to a search warrant from that garage?
Yes, ma'am.
And when you said that the iPad receipt was found in the car, is that the car that you're referring to?
Yes, ma'am.
That is all the questions that I have for you. Thank you.
Cross-examination.
We have just a moment, Your Honor.
The state doesn't have any clarifications for this witness.
All right, thank you, Detective. You can step down. Actually, can I, if you don't mind, I actually have a question.
Of course.
You testified that you didn't send the affidavits and support search warrants with the warrants themselves to Google, Apple, et cetera. And the persons that processed the evidence received, would they have knowledge of and access to the affidavit?
Absolutely, Your Honor.
Questions and follow up to that?
I do. How would people that are getting an email through a portal, Apple, Google, AT&T, how would they have access to the affidavit?
The question was the people that received the evidence, not the people who sent it. So in other words,
The people, he's asking if the police, okay, if the foxes guarding the hen house, right? They got this treasure trove of information, but did they have the affidavit so that they would narrow their own review of what, say, Apple or Google or whoever provided to them, so that they just wouldn't look? They just wouldn't look. They wouldn't look at any of that extra stuff. Why would they do that? Why? What reason could they possibly have? Oh, Judge. This judge is very clever. It's very clever, very dangerous.
the police and team that reviewed the evidence, did they have access to it? Not, that was my
Okay,
question.
I didn't hear you. You do
Just to
have,
clarify.
you do have a soft voice and I am losing my hearing. But so then based on that, how would those folks get access to the affidavit in support of the search warrant when they're reviewing materials?
Just so I'm understanding you, those folks, meaning the people who work for these companies, is that who you're referring to?
No, I think that's not what the judge was
Right, I
asking.
understand.
He was asking that once that evidence is returned and you log it, his question was, do they have access to the affidavit in support of search warrant?
Right.
And your answer to him was yes, absolutely.
Yeah.
How?
There were paper copies of it. It was no secret.
It was
shared
no
freely amongst the
secret?
investigative team.
Okay. But not each person reviewing, various people are reviewing these, the electronic data for the some 67 devices and
Do you have personal knowledge that any of those people ever looked at the affidavit, Detective Payne? That's the question. That's the question. Do you have personal knowledge that any of them actually did look at the affidavit? Because if they didn't narrow it.
third-party warrant returns, right?
Yes, ma'am.
And in terms of my question earlier, which was who I was asking about Apple, who's reviewing that data? Your answer was, I don't know, right?
Yes, ma'am.
So if you don't know who's reviewing something, how would you know that they have access to a search warrant affidavit?
Well, that's the beauty of having a collaborative team effort. If you share the information freely,
Oh.
it's not independent upon
Oh.
myself to provide that to them. Everybody has that information to reference.
That's the beauty of it, huh? You get to share all the stuff, share all the good stuff, just not the bad stuff. That is definitely the beauty of the system here in Moscow.
So is in the database that you're creating with this collective, I'll stop this, break this down. My understanding is that the collective document is Exhibit A, correct?
Correct.
And then when you attach Exhibit A to a warrant with Exhibit A to a affidavit in support of a search warrant, you also add additional language depending on who that warrant is for, right?
Correct. Yes, ma'am.
So there are over 100 different search warrant affidavits in this case. And it's your testimony that everybody who would have access to doing review of data has access to go in and look at what exact search warrant affidavit was executed.
I believe so. Yes.
I have no further questions.
Follow up from the state on that. Right, thank you.
Did they though? That was the key
I think
question.
we don't need to step away, but I do need a break to organize my documents
Just watch you.
for the next witness, who will be Detective Mowery.
Let's go ahead and I don't know how much time she's going to need.
Mowery.
All right, and Detective Mowery can come and be sworn. One of my staff took the opportunity to take a break. They'll be back in a second, so we'll just get them sworn in and we'll wait for them.
You solemnly swear affirm the testimony about to give now before the court is the truth, the whole truth, and nothing but the truth. Thank you.
And I think it's fine if you just want to start with if you're going to ask him his background, you can do that.
Good morning. Detective Mowery, could you please state your name and spell your last for the record?
My name is Lawrence Mowery, Mowery.
I'm just going to take a second to answer this real quick because yes, it is. All of this is prior sworn testimony. And so any deviation from this testimony at trial, they can come back and hand the transcript from this hearing, stick it under their nose. Didn't you say at the suppression hearing that you didn't remember? And now you're saying, you know, whatever it is that you're saying happened. Yeah. Yeah, they can.
What's your current job?
I am a forensic detective with the Moscow Police Department.
And could you tell us about your background in law enforcement?
I have 14 years of law enforcement experience in the state of Idaho. I've been with the Moscow Police Department for the last 6 years in this current role.
What is your role in this case?
I was, I guess, put in charge of lead. I don't know. I was the one that was looking at and funneling the excessive amount of digital data and evidence that was coming through.
Excessive
Have you
amounts.
taken on any other roles? In the
You
space
know,
of
excessive amounts might not have been the best wording here, given that there's an overbreadth argument at stake. I'm just saying, maybe that was not a good word choice.
and had other duties?
If you're asking about serving warrants for digital evidence, then I've done that, yes.
And you've heard Judge Mike.
Yeah, you're fine. Go ahead.
Okay. Do you agree that the Exhibit A that's been discussed was and attached to warrants, that was a group effort?
Yes,
Have you been a part of that group?
I was.
What role did you have in the first AT&T warrant?
I don't recall specifically. I was there when it was being discussed.
You recall that you served that warrant?
I do.
When you served that warrant, did you serve it with the search warrant with the affidavit in support of search warrant attached?
No, ma'am.
Is it your practice to ever serve an affidavit in support of search warrant with the warrant?
No, ma'am.
Were
So
you
none of them do it.
co-located with Special Agent Nicholas Balance as well?
Yes, ma'am.
What was the distance that you had in proximity to him?
He sat in the same lab that I did.
And so was that a cubicle setting? Can you describe the setting?
It's a secured forensic lab. It has a door.
And then inside, is it open? Were you in separate offices?
It's a single room.
Single room. And so you were literally in the same room with Agent Balance.
Yes, ma'am.
And was that for the entire time that he was co-located there?
Yes, ma'am.
Were you aware of his ability to have access to AT&T records without a warrant?
No, ma'am.
The way that she has said this, I mean, she's saying it like it's a given. You know, were you aware of it? It's sounds like he had a back door, had some kind of back door at AT&T, and they know about it. And I don't know how they know about it, but certainly does sound like they do. That's a bit of a problem.
All right, I want to talk now about the cell phone, also known as the USB. Do you recognize that? I should say, I'm so sorry because there are so many cell phones. Bryan Kohberger's cell phone. I want to talk to
The
you about.
physical cell phone or the data from the cell phone?
We're going to talk about both of those.
Okay.
So for purposes of today's argument, we've called it cell phone / USB. How did the state come into possession of Bryan's phone?
Obtained via the warrant in Pennsylvania.
Was a copy of that phone made prior to the search warrant being signed?
Which search
Copy
warrant?
of Bryan's cell phone.
Again, I'm asking which search warrant you're talking about, the one from Pennsylvania or the one that we requested once the data returned?
I'm talking about when it was first seized. So it'd be the first.
The Pennsylvania one?
Right.
I do not know.
So it doesn't matter. So it doesn't matter. So you asked all this clarification and it doesn't matter. That's buying time right there. That's buying time because you don't want to answer. Oh, that's not credible at all. He knows they did it before they got a warrant.
You're aware that a copy of the phone was made and put on a USB.
Yes.
And then a warrant was obtained to search the USB.
Yes, ma'am.
And that's the second warrant.
Yes, ma'am.
Was the cell phone searched prior to the warrant for the USB?
The extraction was created before the warrant in Idaho was requested.
That's not answering the question. That's not answering the question. The extraction was created. That's not, did you look in the phone? She's asking, did you search the phone? He's pausing and answering very carefully here. This is squirrely stuff. Red flags flying already. Of course, they sat and thumbed through his phone. They sat and thumbed through his phone. They downloaded it to a USB. They looked through everything on the USB, and then they did an extraction because the extraction wouldn't show any record of any of that. These guys aren't that clever.
Was the extraction searched before the warrant was obtained in Idaho?
No.
And how do you know that?
I was the one that received the extraction.
And like a good little boy, the Christmas present sitting right there, and he knew right where it was, but he didn't go look at it. Nope, he didn't spoil Santa Claus's surprise. He waited for that warrant. What a good boy.
The extraction, where was the extraction made?
Pennsylvania.
And who made that extraction?
I believe it was Special Agent Tanzola.
And how did Special Agent Tanzola get that extraction to you?
You'd have to ask him. I believe it was using a Cellbrite product.
So what about is the USB not a physical box of the extraction, or is it all digital?
USB is just a storage device that the data would be placed onto.
So with the extraction and the USB, can you explain the process of the extraction being made and it getting to you and it getting put on a USB?
Normally in a forensic environment, the device is extracted, that's extraction, and then therefore be placed onto a different storage device for evidence storage or for sharing with other forensic investigators.
And so you said normally, but I'm asking you specifically to Bryan Kohberger's cell phone.
The data was placed on a storage device by SA Tanzola and provided to me.
And how did you get the storage device?
I believe it was brought back. I don't recall how I was given to it. It was still in the FBI packaging.
Do you have any personal knowledge of whether or not Special Agent Tanzola reviewed the data of the extraction before the search warrant in Idaho was obtained?
I don't recall.
Okay. Judge, this is when you don't have yet either. This is Defendant's Exhibit A to cell phone. And it does have a
Do you have an extra copy of that?
pardon.
Do you have an extra copy of that?
The ones, did I handed two, right?
Yeah, and just in going forward, I need 2 copies.
I will. I heard that message yesterday, Judge, and I apologize. Moving forward, I will make sure that there's that extra. I'm assuming you went up for your clerk. So.
My staff attorney,
Yeah,
yes.
yeah. Okay, that's not right.
And just for the record, as I've been doing, this has been marked Defendant's Exhibit Number A with a date on the sticker of 11/14/24. The document on which the sticker is placed, first page is affidavit for search warrant.
Was it searched before they got the Idaho warrant? Was it searched? I mean, here's the thing. Like, even doing the extraction, they're going to want to hang this on a technicality of, well, just doing the extraction isn't really, see, an extraction is a seizure, right? You're seizing all of the data in the phone, and that's, yeah, normally you got to get a warrant to be able to do that. And so they're really going to try to hang their hat on saying, well, but they didn't look at it. If they didn't look at it, this is a whole like tree falls in the woods kind of argument. It's not a seizure if none of them looked at it. That's really where I think this is going to go. And how do you know the FBI didn't look at it? Penzola did it, or whatever his name was, Tanzola. I couldn't quite tell exactly, but something like that. Special agent, another FBI guy. It's always the FBI. FBI did the extraction. This is just a mess.
Directed to the Moscow Police Department Forensic Lab.
Detective, how did you create the affidavit in support of the cell phone of the USB warrant?
How did I create it?
Yes.
So I'm not understanding. That's a vague question.
How did you go about drafting this? Is this a document that you had, that you filled in from, or did you start from scratch? How did you
I
come
don't
up?
remember the exact way that I did it, but it's not, this isn't very different from, say, an ICAC warrant that I would have had previous intentions to search the cyber tip information that would be already placed into evidence at the digital forensic lab.
So when there's knowledge about what you're asking for and lists of things to get, what are you basing that knowledge on?
I would be basing this on information that I've done in previous cases, other warrants that I have served, and other warrants that I have.
Can you turn to page 24? You see that page?
Yes, ma'am.
And is that page entitled search warrant?
Yes, ma'am.
Looking at the first paragraph of that search warrant, is there any reference to search warrant affidavit in the warrant?
No, ma'am.
And is the date of the crime on the search warrant?
No, ma'am.
On page 25, can you turn there? There's a directive to search the premises. Do you see that?
Yes, ma'am.
What's the premises located listed as?
155 South View in Moscow, Idaho, in the forensic lab. 155 South View, one word.
Does it say USB in that
Search the lab.
descriptor?
No, ma'am.
Oh my God.
Can you turn to page 28?
You got authorization to search the lab, but not the contents of the phone. It's some great police
Who
work
is Key
there.
Computer Forensic Lab?
Key is not a person, it's a thing. It unlocked the secure cubicle that the USB was placed into by myself so that it was secured. I had the key, and entrance was obtained by Key in the computer forensic lab.
That makes sense now. I thought it was the name of a company, and I don't know why. That makes sense.
So he really did his paperwork as if he's searching like a room instead of searching a cellular device. And this is what he says is based on his prior experience of other things that he's done. I don't know who the heck taught him to do it this way. But no, in fact, it's particularly terrible because say police have authorization, say they got a search warrant to come and search your house. And in your house, they find your cell phone and they want to get into your cell phone. The authorization to search your house doesn't authorize them to get into your cell phone. They have to get a separate warrant for that. Yikes.
Key Computer Forensic Lab. Who was ultimately in charge of searching the USB drive?
The data was extracted, or not extracted, but reviewed by several different people.
Okay, who are those people?
I don't know all of them. Myself looked at some of the information, but not all.
And you said you don't remember all of them, but who else do you remember?
The information was also given to the FBI. The FBI had that information and they examined it.
And do you know who with the FBI?
No, I do not.
Can you turn to page 27? Can you look at page 6? Or not page 6. I'm sorry. Number 6, line number 6. Do you see that? What does that say?
A copy of the warrant inventory sheet were left with the drive.
And that does not indicate that a copy of the search warrant affidavit was left with the
Good
drive.
one.
Is that right?
No, ma'am.
Okay, I want to talk Amazon. Did you swear to several warrants for Amazon?
I did.
Do you know specifically how many?
I do not recall how many.
How were the warrants served? How did you serve Amazon warrants?
I believe that Special Agent Michael Douglas assisted in service of those.
What training do you have in Amazon accounts and records?
I do not have any training for Amazon specifically.
And I think you answered my next question, but there was a reference in the warrants to a special agent locating an Amazon account. Is that the Special Agent Douglas?
I don't recall who was that, who found that information.
How was an Amazon account located?
I don't know.
You know, this is the funny thing with this group process, right? And it's the diffusion of responsibility, the diffusion of accountability, right? It's so convenient. It's just it's such a wonderful thing, as Payne put it, because you know, everybody has access. That's the beauty of it. So everybody has all the same knowledge, and because of that, nobody has any knowledge. It's so diffused that nobody knows anything because the other guy knows it, that guy knows it, but at the same time, we all know it. This reminds me of the whole issue I had with the Rust case, right? The Alec Baldwin prosecution, and the standards that they had on the set, where like everybody, this person has this responsibility and they're overseen by this person with this responsibility, and that one has responsibility for the other. And it was a system that just basically diffused the responsibility for keeping the guns safe so thoroughly that no particular person could be blamed, because they could always point to the next person and say, well, that person, if they had done their part, this wouldn't have happened. And so all of these guys with no memory, that's what this is about. That's part of why they do things like this. I don't have to be responsible for remembering anything. I was that other guy. I can get the benefit of it when I need to invoke the fellow officer rule and pretend that I personally have personal knowledge of all this stuff that I'm putting in my affidavit. And then when it comes time to answer for it, nah.
In your affidavit, where you've got language that talks about what Amazon holds and how it identifies and the list of items that can be collected, if you don't have any training in doing an Amazon warrant, how did you know that?
I was relying on the experts that have worked with or served the warrants to Amazon previously. I believe that information came from Special Agent Michael Douglas.
And in your affidavit, did you indicate that that was based on your knowledge or on someone else's knowledge?
I based it on mine because I spoke to Special Agent Michael Douglas about it. And he was the one that informed me that this was the information that we could request.
That's not your knowledge. That's literally hearsay. That's like exactly the opposite of personal knowledge. That's somebody else's knowledge. Oh, it's not your personal knowledge because somebody told you. Oh.
And so did he provide you with a kind of a mock-up affidavit to use so that you would know what language to include?
I don't remember if he gave me a mock-up, but obviously he would have helped me with the wording of it.
The wording of the warrants is pretty technical, right? All the list of items that is asked for.
Any electronic service provider usually has their special way of asking for things.
And so since you don't have training in Amazon, you relied on Special Agent Douglas for that?
Yes, ma'am.
Okay, Google is the next one I want to talk to you about. What's your training about Google?
Again, I have no specific training to Google. I've served various email or warrants on Google for other means.
Is your experience with Google isolated to this case?
No.
You've done before?
Oh, yes.
How did you get the form that you used for the Google warrant in this case?
The Google form, I probably relied on previous warrants that I've served.
Do you know how many warrants you obtained for Google in this case?
It's 3.
On January 3rd, that January 3rd, 2023, that warrant asked for Bryan Christopher 1994 at Gmail, 2 phone numbers, and an IMEI number. What's an IMEI?
International Mobile Equipment Identifier.
And how did you get that number to put in the January 3rd, 2023 Google warrant?
I do not recall.
You don't recall how you got the IMEI? You don't recall what IMEI even was it? It's kind of important to know because you're supposed to be asking for stuff in a warrant for a reason, right? It's got to be particular. It's got to be focused. It's not just, oh, here's a thing I found and I'd like to look at it some more. No, there's a reason for it. Your justification to search is limited to by the probable cause that you have to believe that there's likely going to be evidence found there. So you really should know what it is that you're asking to search.
Okay.
I just want to pause this real quickly because yes, you just go into your phone settings. Some of them I think even have like if you open up the back or like there's parts of it you can open, it just depends on your phone. But yes, it's in your phone settings. You can get the IMEI. The question is, what IMEI is this? Is this Bryan Kohberger's phone's IMEI? Is this the IMEI for a different device? Is this the iPad? What is it even? If you don't know how you got it, what even is it? That's what I'd like to know. I'm off now. Yikes.
Were you, in preparation for creating these warrants, were you having communications with Google?
Specifically about these warrants?
About being able to get the data via warrants?
I don't recall communicating with them specific to these warrants.
Okay, I'm going to hand you what's Defendant's Exhibit F to the Google Memorandum in Support. You recognize that?
Appears to be an email between myself and a Francis from Google.
So is this how you were communicating with Google via email?
I was communicating with Google for other, I'm not sure if this is the one for this specific warrant, I guess is where I'm getting at. There was question of what Google could provide. We served Google at one point with a warrant. They said it was, they couldn't do it because there would be too much data. So they were trying to assist us in, well, basically not spending $100,000 of getting them data.
Kind of funny how he didn't remember communicating with Google and now suddenly has a lot of pretty specific memories about communicating with Google about warrants now that there's an email right in front of him. Doesn't it? Doesn't that maybe call into a little bit of question, this whole not remembering? And how maybe not remembering is just a little bit of a dare. It's an invite. It's a, do you have something that you can stick under my nose to force me to acknowledge? That's all I don't know seems to mean here. Suddenly he remembers this whole story. Oh, we were having all these problems and I just said it might not have been this specific one, but would it have related to this one? Yeah, it probably would. And so that probably would be a communication with Google about the warrant. Did you use that information about this warrant? It probably wasn't another case, was it? Because you wouldn't be submitting that in discovery in Bryan Kohberger's case. It related to Bryan Kohberger's casework, and it was with Google, and it was about warrants. So just let this be a really good demonstration of what the squirreliness means when they don't remember, they don't recall, or they use this, you know, they use this narrowing stuff. I don't know specifically about these warrants. That's what they do. That's how they are trained and how they learn over time to answer their questions. They answer the question that they want you to have asked, not the one that you actually did. And so pay attention. Pay attention to that. Pay attention to what the actual question is and what the actual answer is. And I bet you'll notice a lot of times they're not answering the question that's being asked. She didn't ask, did you communicate specifically with Google about these warrants? But that's the answer.
So to be clear, when I'm talking about the communications generally, I'm talking about your communications with Google about all the warrants. So was there email and telephone communications or just email?
I believe I spoke with their legal representation on the phone. I don't remember if there was other conversations.
Do you understand the difference between a personal account and a not personal account on Google?
I do not.
Well, there's reference to DeSales and DeSales helping from their end. Can you explain that?
I don't recall what that means.
Do you recognize what DeSales is in the court?
Don't recall, don't know what that means. You were trying to get this information from an alternate source because Google wasn't going to give it to you, and you don't remember anything about that?
Course of this case.
It references an email address that was associated with the defendant.
Okay. And that email address associated with the defendant is a college that he attended, right?
Yes.
And so was there communication with DeSales about them not wanting to produce records pursuant to a warrant because it was educational records protected by federal law?
I was part of a little bit of that. Officer Detective Payne knew more about that conversation, but yes.
And so what I'm trying to understand is what was DeSales doing to help?
I believe DeSales was just waiting for a warrant. I don't recall completely.
And did you serve the Google warrants?
I believe I did.
I believe you said you did?
Yes.
And consistent with what you've said earlier, you did not include an affidavit in support of search warrant with that? Why did you choose the timeframe of January 1st, 2021 to December 30th, 2022?
I don't recall the specific reason why we went back to January 1. It was to include the time that we believe that the defendant had entered Washington to become a student nearby the crime scene and just prior to that.
Just prior to him coming to Washington? Didn't he come to Washington in August? Maybe July? Just prior to that, like half a year? Like more prior to that than there was time after that between then and the murders? Again, with an overbreadth challenge, this is something you should know. You should know your reasoning for why that date mattered. Because the whole argument is that you went and just got a bunch of stuff that wasn't relevant to what you were trying to investigate, just so that you could have it and poke through it and see if you found some things. Classic fishing expedition stuff. So I'm just a little bit surprised that he wasn't, I don't know, prepped a little bit better with some of this. Like you should have a good answer for why these dates mattered to your investigation, because that's kind of the question the court's going to be answering.
But you know that he didn't come to Pullman, Washington until June of 2022. Right?
June, all right.
Correct.
Did you review the Google warrant return emails?
Yes.
Did you review? So you said you reviewed them. Are you the one who's in charge of evaluating those materials for this case, or is that designated to somebody else?
The materials came to myself, at which time it was disseminated to other investigators and the FBI as well.
Is it fair to say that between warrant 1 and warrant 3, it's gone from 2 gigs to over 13 gigs of material?
It was substantial information.
And have you done anything to verify whether or not the materials produced are within the scope of the warrants?
I usually make sure that they were from that specific account when it's received, but I did not go into depth of the evaluation.
So they didn't narrow. They didn't narrow in the execution. Despite whether or not the affidavit was available, they didn't actually limit their review to whatever the ostensible justification in the warrant for looking at it in the affidavit was. They're really bombing on the overbreadth, and I'm telling you guys, it's one of the strongest legal arguments they have for a lot of these warrants. It's one of the strongest ones they have, the Apple in particular and the Google also. So much information that's available. I mean, just all 2 gigs to 13 gigs. What's on your Google account from your Android phone? I mean, they give you a little dashboard. You know, you got your Google Drive, you got your Google Photos, you got your Google Wallet, you got your Google Note. I mean, you got your calendar, you got your location, your maps, all this stuff. And he can't even tell us why they needed that all the way back to January, other than maybe they wanted to fish around in it some. It's not good. This is not looking good.
Let's talk, the final area is about the Apple warrant. What was your role in those warrants, in that warrant? Sorry, not plural, singular.
I don't remember that specific one. I know I was involved in a lot of the Apple iCloud warrants.
What kind of communications did you have with Apple to facilitate getting the warrant?
I don't recall prior to.
I'll hand you what's been marked as.
I love it. Train him. Train him, Ms. Masseth. Get him ready for trial. He doesn't remember, have something to hand him. That's the way to do it, because now I bet we're going to get a really specific story about what he does in fact remember, because he's going to have to, he's going to get defensive over having this thing under his nose. And the judge's body language now, he's way more attentive than he was yesterday, but he's got that, holding back, covering his mouth kind of position, sitting back. This doesn't necessarily look like a particularly happy judge. Now, granted, he hasn't struck me as all that expressive, but yeah, I'm not getting the impression that he's all that impressed.
Defense Exhibit C to the Apple warrant. It does have a sticker on it. And it's not to the Apple warrant, it's to the memorandum in support.
Exhibit C attached to their memorandum dated, exhibit sticker dated 11/14/24. Appears to be a printout of some emails.
Have you reviewed those?
Yes, ma'am.
Can you, does that help refresh your recollection regarding what communications were occurring?
It appears that there was communication between Apple and the FBI.
Okay. And were you included in that?
I believe I was.
Okay. And did that include chats,
I believe the word chat means to chat, to talk.
like telephone talk or Zoom talk, or what was the method?
I believe it was telephonic.
So what kind of help were you getting from Apple, and what was the FBI getting from Apple?
I don't recall the conversation. This was more specific to the FBI's current investigation. As I stated in my email there for the stalking investigation, I was merely just privy to their conversation.
Have all of their materials related to that been turned over?
Who's there in that sentence? Counsel?
Pardon?
Who's there in that sentence?
Sorry, FBI.
I do not know. I wasn't, yeah, I don't know.
I have no further questions.
A few questions, Your Honor. Can I stay here? Okay. That'd be good. Just a few follow-up questions.
Are we going to get Ashley Jennings?
When you received the evidence back from these various providers, did you have access to what we refer to as affidavit for search warrant and Exhibit A?
Yes.
Okay. And did you use that to determine the scope of what you would be searching for from those providers?
If I was to be doing the investigation, yes, I would have looked at those items.
And you testified that several
Sure.
investigators helped MPD in review of evidence back from providers.
Yes.
To your knowledge, did those investigators have access to the affidavit and the Exhibit A?
Yes.
I don't have anything further. Thank you.
You redirect.
Personal knowledge that they did in fact do that. That's important. That's a miss. That's a swing, and that's not even a swing. That's watching the ball go by.
All right, why don't we take a 10-minute recess and we'll then pick up.
Ugh, I don't like that. I don't like that door that the judge clearly wanted to open. He asked that question the first time, and then so then Jennings picked up on it and is going to make that argument. And you needed to take it out of the potential realm, right? Okay, maybe potentially they could have. It wasn't like the affidavit was under lock and key, but did anybody actually do that? There's no proof that they did. It's important to establish that. Hopefully this won't buffer for like half an hour before it gets going again. Oh. Just let this be a record of Starlink performance down here at the far side. Booted, but I'm back. And so is the court. Can't see it. Okay, here it is. Argument. Phew.
Judge,
No
I'm going
harm,
to
no foul.
cover several of the warrants, and then Mr. Lawson's going to cover 4. So I'll just wrap all of my argument up instead of getting up and down for each one. My oral argument is not meant to rehash every point briefed or every argument briefed. I'm giving you big picture comments based on the testimony, but I want to make it clear that we're not waiving any written arguments. While I question Corporal Payne and Detective Mowery about some exhibits, but not all, it was not an indication that others are not important. I wanted to make important points, but not belabor. With IGG and Franks having been addressed yesterday, and the fact that the primary issues that I'm addressing have to do with general warrants, I'm not going to rehash those arguments, and I'm going to focus on the legal issues, beginning with the AT&T Warrant 1, pin, trap, and trace, also known as AT&T 2, and the cell phone / USB drive. The Fourth Amendment requires particularity sufficient to
Mhm.
prevent the exercise of discretion by an executing officer.
Mhm.
The particularity requirement's objective is that necessary searches should be as limited as possible.
Mhm.
A search warrant must be particular enough so that as to what is taken, nothing is left to the discretion of the officer executing the warrant. The government cannot seize the haystack to look for a needle.
Yes.
And there is an undisputed privacy interest in cell phone data, including cellular site data pursuant to Carpenter. All three of these warrants were issued in December 23rd and early January 2023. The two AT&T warrants were issued on December 23rd, 2022, within an hour of each other. The first did have a temporal narrowing. AT&T one had November 12th, 12 a.m. to November 14th, 12 a.m. The warrant itself was extremely broad and did not incorporate the affidavit. In support of this actual failure to incorporate, the officers admitted that they did not incorporate in the search, but to the extent that the state is going to argue that when the warrant says upon offer and proof, that is the same as hereby incorporates an affidavit, I pointed out the language in certain search warrant affidavits to show you that they do know what it means to actually use the language herein is incorporated Exhibit A. And that same language is not used in a single search warrant affidavit. So the incorporation that would be a remedy for this issue potentially of particularity doesn't exist when the search warrant affidavit is not included. Even if for some reason you were to determine that there was English language meaning upon proof and oath is the same as hereby incorporated, the language in the search warrant affidavits themselves is extremely broad. The affidavit of return signed by Detective Payne, this is on affidavit AT&T 1, says that the warrant was served by email, and as he indicated, it did not include the search warrant in support.
The affidavit.
The description of the property in Exhibit A to AT&T described the property as just a phone number with no other description of the property, which indicates a lack of knowledge of what was actually seized and going to be searched. The second AT&T warrant and install pin trace was requested within 1 hour of the first warrant return at 3:50. The data from warrant 1 was analyzed such that by Special Agent Balance, such that Detective Payne was relying on Balance in his affidavit to support it by saying that the data that had been in their hands for less than an hour supported that the phone was possibly off going south on Pullman at 2:42 a.m. And there is just got to be a question for everybody of how does this massive amount of data
Mhm.
get in an hour to create a second broader warrant?
That is a question. If they only just now have come up with the direction of travel. I mean, that's what they described. That's what they described in the PC affidavit, right? That they got the initial one, and then they got the pin trap and trace. Went through the systematic process of accumulating these records from AT&T and built on each subsequent one. So if that's the point where they built in, the phone was turned off and the directionality of the travel and so forth, in 1 hour, I agree. Yeah. That's, I don't know. I mean, I don't do that work, but I have a strong suspicion that maybe Cy has a little something to say about that. Obviously not here and in this hearing, but in some context.
The warrant language in AT&T 2 pin trap trace is extremely broad, and the time frame goes from June 23 to 2020, June 23rd, 2022 to present. The crime of homicide was stated, but the date of the crime was not stated. There was no other specificity in the actual warrant. The warrant asked for extensive data, location data, timing reports, cell tower information, and installation of a pin trap and trace, among other many things. And when the warrant was served, a check the box form was included as a cover sheet to AT&T. Turning to the cell phone is first seized when Bryan is arrested. It's copied by Special Agent Tanzola without a warrant, and then that USB drive makes its way to Idaho in an unclear fashion. It sounds to me like it came back with Corporal Payne, who was there for the arrest.
I don't know this. Maybe there's tech people in the chat who know this. But is a USB going to record? Is it going to have like a log, an access log, or anything like that somewhere in its own data or not? Just be curious about that. Seems like there should be some kind of way to figure that out, but I just don't know.
And when that warrant is obtained for that USB drive, it's put in a safe with just a copy of the warrant that has no date of the crime, and there's nothing particularized about what is to be searched. This creates a general warrant with 100% total discretion and nothing to limit the search. And if you believe that access within a database by somebody unidentified other than Mowery, who's going to evaluate that warrant, that they're going to look and pull that finalized search warrant from the database that everybody supposedly has access to, looking at that search warrant affidavit, there's full discretion to search the USB drive. There's no limitations and no efforts taken to address that. Turning now to Google and Apple. A very instructive case on Google and Apple is the Idaho pilling case, which is 721 F Sup 3D 1113 2024. It's almost totally on point with this case. It is a federal case out of the District of Idaho, but it really couldn't be more instructive in terms of looking at these issues with Google and Apple. There's without a doubt a recognized protected interest of private information in Google and Apple records. Google contained private emails, schoolwork, research, among things, and Apple was essentially a copy of a phone and iPad that went all the way back to 2016. 2018 was an indication of when an iPad was purchased, but 2016, according to the documents that were prepared, were when it was identified that an Apple account was first created. Carpenter applies, and to the extent that there may be third-party materials like search history not related or documented, nothing was done to do any sort of segregation with regard to Apple or Google. For the Google warrant, by January 3rd, 2023, law enforcement knew many details that they could have used to narrow those warrants. They knew that Bryan hadn't been in Pullman until June of 2022. They knew the names of the deceased, which were not included as language in the Google warrant. They knew the fraternities and sororities. They knew the students' names who had also been at the house on the morning of November 13th, 2022. They knew the date of the crime, of course. They knew emails. They knew social media accounts and names. They knew where students worked. They knew their friends. They knew their phone numbers. None of that was included in the Google warrant to help limit and make that something other than a general warrant. There's no language incorporating these search warrant affidavits, making these broad, sweeping categories, making the productions bigger and bigger. In Google, it went from 2 gigabytes to 13 gigabytes by the third production. And it appears that it's really unclear to these detectives that have taken a huge role in this case, who's evaluating what data and to what extent and what is being produced by it and what is within the scope of what is in an already broad warrant. For Apple, we are missing some sort of legal process that the state just hasn't filled the gap on, and these witnesses don't fill the gap on. We don't know what the legal process is that is referenced between the first request for preservation when there is a production on a warrant. The steps that have been taken in between to get the information to put into the warrant are completely unclear. And to the extent that these officers who swore to the contents of affidavits now have no memory of what that is, that's invalidating of those warrants. As for the arrest and the car and the apartment, what I will close by saying on those, because it's not an issue of general warrant or a discussion of particularity, those are more reliant on the issues associated with IGG and Franks. And with that, I'd ask that you find that the warrants that I've just discussed are general warrants, not particular warrants, and they should be suppressed.
She's got a good argument. These are extremely broad warrants. It's
You wanna
no
respond to that, or do you
question.
wanna have the
It's protected.
defense argue the additional warrant issues and then address them all?
I'll take your lead, but I'm happy to just address, to piecemeal this, and I can address just this.
What does she have to say about
can make this
why these warrants
pretty
are
simple for you. You
fine?
don't have to go down the rabbit trail that the defendant would like you to go down. The search warrants regarding the particularity requirement. In this group that we're talking about is Apple, AT&T, there was a first and a second, Kohberger's phone, and then Google. All of these warrants were not general warrants. They were all sufficiently particular. They were specific to the type, each one of them listed that they were specific to the type of crime, the location, and all but one of them had temporal limitations. And for the one that didn't, that would be the cell phone warrant. That warrant was more particularized in the types of data that officers were allowed to search for. It's the state's position these were not general warrants. The court can determine that just by looking at.
She's basically saying as long as you put any limit on it whatsoever, it's not a general warrant, even if the limit that you put on it has no relationship whatsoever to the probable cause that's supposed to justify it. And that, unfortunately, is simply not the law.
If you have any questions, otherwise, state submits, you should deny the motions to suppress for these issues.
I like how he just sits there quietly. He doesn't give him anything. This is a tough judge.
Your Honor, I was asked to argue the motion regarding the raid on my client's parents' home, the search of his person here in Idaho, as well as in Pennsylvania, as well as and the Amazon warrant. I think for the most part, I'll just rely on the briefing. I just want to clear up a couple of things. One of the areas that was covered in the Pennsylvania home raid was that the state had to have a valid warrant in order to enter the home. I think in the briefing it gets a little confusing, but the point was not that Mr. Kohberger couldn't have been arrested as he was walking down the street via the usual channels in which that could have occurred. The point was that they had to have a valid warrant in order to get into the home. The only warrant that they have is the one that we're challenging and via the Franks motion. And so that was the purpose of that argument. The other issue in terms of choice of law, it sounds like the state's kind of accepting that Idaho Constitution should apply. We set out a few different reasons why that should be the case. It doesn't seem like there's a big argument going on there. So unless the court has questions about it, I'll leave that alone. And then the other issue that I wanted to touch on is the right of privacy in the information that we have in our Amazon goings about why should the state have to have a warrant for that. We set it out pretty well in the briefing, but I think the big concept and takeaway here is in Carpenter and Riley, the United States Supreme Court starts doing something different. And I think what the court is starting to recognize is that to a great extent, the United States has become a sort of panopticon. That is,
Panopticon!
Concept of panopticon.
Oh my God! Jay Logston is going with the panopticon. Okay, I love this man. Not more than my husband, of course. I love my husband, but wow! I didn't think anybody else ever was going to talk about the panopticon. Give it to me, Jay.
Panopticon is you have a prison in which you only need a small number of guards because you have a very heavy-duty surveillance system. In the United States, we have via our phones, via the internet, much of what we do is now surveilled and very easily accessible. And so the fact that we have the third-party doctrine made sense when it was being adopted back in the 70s and the 60s. It stops making sense once all of this information is easily accessible in the way that it is. And so our point is that the judiciary has to have a role in this. There has to be a judge between us and the executive Otherwise, we're essentially allowing the executive to know everything about us all the time. And so the state makes the point that similar to the one that Professor Kerr made about going and getting bank materials. Once those were things that could be done simply and efficiently via these records, a person didn't have to go out and get the cash. The state argues in this case, because of Amazon, Mr. Kohberger didn't have to go someplace to purchase items. All of that would have been out in public, but he's doing it on his computer. And so why should that make it private? And the reason why that has to become private, Your Honor, is because of the vast amount of information that is now so easily accessible to the government. If we don't require a warrant, we essentially put all of ourselves at hazard of being snooped on at any time. And so I also just want to briefly bring up, I think yesterday the court had talked about privacy rights with the IGG databases. And I certainly want to make sure that we are preserving that argument. We included it in the briefing. We do believe that Americans have privacy interest in the genetics they share with other people,
Okay.
and that other people then place within these databases.
Thank you.
That is not something that we intended to abandon in any way yesterday. If the court has no other questions for me, I would rely on the briefing.
Thank you.
Thank you.
Your Honor, I'd like to address just the third party doctrine, and then I'd like to turn it over to Mr. Thompson to address the other motions to suppress. And the case that we're talking about is the Amazon records, and that's what has to do with the third party doctrine. And the US Supreme Court case State v. Miller is the controlling case here. And Idaho courts, as explored in my briefing, apply Miller. And there's no reason for this court to diverge from that Fourth Amendment analysis. The documents are Amazon's business records. They detail transaction history. Business records are most akin to bank records, which is allowed. Applying the court's reasoning from Miller, again, these documents are business records of Amazon. They're not the defendant's private papers. Amazon is a party to those transactions. They have a substantial stake in these records. And the defendant took the risk when he revealed his affairs that this information would be conveyed by Amazon to third parties, including the government. It's the state's position, and it should be the position of this court. The defendant does not have a Fourth Amendment privacy interest in Amazon's business records. Thank you, Your Honor.
Make sure you got that too, guys, right? Just like yesterday, you put your DNA in the database, means according to the government, no more privacy interest in your DNA. It's gone. They can do whatever they want with it. Yeah, same thing with shopping at Amazon or doing anything at all with Amazon. And you think it's going to stop at Amazon? No, it won't. It won't. Not in the digital frontier. It'll change. You just assume the risk by engaging in online activities, and so Facebook, Instagram, all that stuff. It's their business records. Yeah, disturbingly.
Good morning, Judge. I'm going to address, I guess, the remaining warrants or the questions raised by the defense about the remaining warrants. I'd like to start first with the warrants for the residents in Pennsylvania. That expands into Mr. Kohberger's person under the Pennsylvania search warrants for his person, for his in Pennsylvania. And then the defense also raises questions about statements made by Mr. Kohberger to law enforcement. First, as to 119 Lamson itself, one of the first things the defendant offers to the court is claims that there was no local warrant, valid local warrant, and that simply isn't true. As the record clearly demonstrates, there were 3 valid local warrants, Pennsylvania warrants, for the residence, for the defendant's person, and for his car. The defendant then asserts, and I appreciate Mr. Logston's clarifications, but essentially the defendant asserts there needs to be a separate special warrant in order for Pennsylvania to take the defendant into custody as a fugitive from Idaho on our charges. And as we cited in our briefing on this, the statutes in Pennsylvania and Idaho are virtually the same, and they clearly contemplate that a felony fugitive can be taken into custody without a fugitive warrant under the circumstances that exist in this particular case. Now, if the issue is the law enforcement presence or access to the defendant inside his parents' residence, we would submit that's already addressed because Pennsylvania State Police had a valid search warrant for the premises, for the defendant's person, and for his car.
So they had lawful process to be where they were, where they found the defendant and took him into custody as a fugitive. The knock and announce, there was discussion earlier today on the explanation of what happened with the dynamics of the knock and announce. That's detailed in Sergeant Lang's statement, which is now has a current cover affidavit to it filed with the court. That's S5. I'm not going to publicly go through all the factors unless the court wishes me to, because they are quite incriminating as far as the applicable factors that justify either an abbreviated knock and announce or, frankly, elimination of knock and announce entirely. And from what we have before the court now, it's clear that the Pennsylvania police were operating in a dynamic sense, reacting to real-time information that was coming in. That's all documented in the various reports and log sheets that have been submitted with our pleadings, which are not particularly lengthy in nature. Finally, as to the defendant's statements, I think the key notion here on any statements the defendant made, and frankly, he really didn't make much in the way of incriminating statements, is there was never any interrogation. He was Mirandized eventually, but even in the prior conversations that occurred with Pennsylvania law enforcement, there was never interrogation. And so Miranda is not implicated, and so there's no issue on the statements themselves. As to his car and his person, as I've already mentioned, there were valid specific Pennsylvania search warrants for each of those. So those are presumed to be lawful. There's been no substantive attack on those. There is a motion to suppress regarding, and I'll use the air quotes, arrest warrant. And frankly, I have yet to be able to figure out what arrest warrant is being referred to. But again, all the actions in Pennsylvania were taken pursuant to valid warrants, search warrants from the Pennsylvania courts and the applicable fugitive arrest statutes. And so
It was
we
the
don't see that there's
Idaho
any issue
arrest
before the court
warrant.
there. The defense also raised the issue of a search warrant for the defendant's person in a separate motion, which appears to be the search warrant for the defendant's person here in Idaho when he was returned to Idaho. And as the search warrant and the affidavit for the search warrant show, which were attached to our reply, there was a valid search warrant for that. I think any issues to be argued beyond that relate to the IGG and Franks that are already pending with the court. As far as the defendant's, the search of the defendant's apartment in Washington, for whatever reason, the defendant did not include all the documentation with their particular motion to suppress, but we provided that in our response, that there was the Washington search warrant. There was also an amendment to the Washington search warrant. The Washington search warrants, the applications, included all the information, the Exhibit A information from the state, and then the WSU Police Department added their additional state of Washington specific information. There's nothing to question the validity of that warrant on its face. So, Your Honor, unless the court has questions, I don't have anything further to offer in the way of argument. Oral argument.
Thank you. Thank you, sir. Thoughts on any rebuttal?
I think I just rely again on the most part. In terms of the knock and announce, I think the totality of the circumstances of this particular raid are something that the court has to be cognizant of. If Dylan Roof could essentially be picked up in a parking lot outside of a drugstore or whatever it is that they were able to do.
Facts about which I have no idea, and so it's not going to be helpful to compare it to
Well,
whoever Mr. Roof is. So
I guess the point is that in this particular case, the state manufactured the exigencies, if they had them at all. The reality is, as they explained in their own affidavit, they're essentially watching Mr. Kohberger as he moves around his house via snipers. I mean, they were quite safe, and there was simply no reason to bash the doors in.
This is what I'm saying about them being a little bit, you know, sometimes a little bit crybabies about safety. This is what I'm talking about. They had freaking snipers. They had snipers pointing rifles at him inside his house. But they can't take 5 seconds to knock and say police before they bang in the door. That's going to make them somehow more unsafe. It's ridiculous. It's ridiculous. There's no absolute safety anywhere, but that's kind of the standard that police expect the courts to apply. And courts, by and large, are willing to do that. They're willing to bend over backwards and say, anything that makes the police more safe. Doesn't matter if it violates your rights. Doesn't matter if it wouldn't be permitted in other types of contexts. Officer safety. The officer is scared, so he gets to do it. Ugh, snipers. And they can't take 5 seconds to knock and announce.
momentarily after yelling from their barricade.
There's two issues. There's officer safety. There's also destruction of evidence concerns.
In the cases that we cited, Judge, when the claim has been that there's evidence being destroyed, the evidence, what's known to the officers is something along the lines of, they hear somebody running away after they announce themselves. It's not typical that the police simply don't knock and announce at all in those cases. They usually give the person the opportunity to surrender, but it's not a particularly long one. And in this case, they don't do that at all. And the only thing they knew is that he's walking around from room to room and that he has some kitchen gloves on. And I don't think that that equates necessarily to the destruction of,
That's not all.
So he's walking around from room to room and he has some gloves on. That's the exigency. And that gives rise to destruction of evidence concerns.
I won't go into the detail in order to.
So he says that's not all. Okay.
So as that we don't go into those issues.
Thank you, Judge. But beyond that, we'll rely on the briefing. Thank you.
Okay. I'll take the motions to suppress under advisement and issue ruling forthwith. The next issue is the state's motion to compel regarding the defendant's expert disclosures.
I'm sorry, Your Honor, the defendant's motion to compel us.
Did I say the state's motion to compel? The defendant's motion to compel regarding the state's expert disclosures.
We did file ours yesterday, so their motion may be coming.
Well, I would be impressed if they had filed something already on that, given they were just served yesterday afternoon. So
They were. Thank you. Your Honor, we are here on our motion to compel, asking that the court remedy what the state has done with their expert disclosures. We rely on Idaho Criminal Rule 16 and the court's order setting out what we should do and when we should do it in this case.
let me ask a question from a framework standpoint. I don't know what these folks are going to testify to at trial specifically as it relates to what they've disclosed. The way expert disclosure issues usually works, I don't tell a party what you have to specifically disclose about your experts. You disclose about what you think you need to disclose. If you haven't disclosed it consistent with the rule and you try to offer it, there's a good chance it may not come into evidence. That's the general framework. So I'm a little, I guess, concerned about what appears to be you asking me to tell them what to say in their disclosures.
The court brings up a really, really good point. And I think it's a remedy the court has and one that we would hope and ask the court to issue in this case. I think when we filed the motion, Your Honor, we had a couple of disclosures that could appear to be disclosures with wiggle words in them.
Yeah, wiggle words are not going to save the lack of disclosure. I'll let the state know that right now. The fact that you say, well, you could talk about anything else, doesn't mean he's going to get to talk about anything else.
In an abundance of caution, we were worried about those words. I appreciate what the court's saying, and I'm going to make this really short. The lists are problematic for us. There are 4 or 5 experts with lists. I understand what the court said. I like what the
They
court
also
said.
have reports that they reference.
The lab people do have reports. I understand those are their opinions. When we're talking about, and I'm going to specifically talk to you about their disclosure number 7, it's an FBI agent, Douglas. There's a list of financial records that he collected and looked at. Other than that those records exist, there's not a report telling me what they mean to him at all. If he's limited to say, I collected these records, this is what we have.
My understanding, the state can correct me, is what I understand from the briefing is respect to that. I think that's the Amazon documents, correct?
Those were some of those documents, Your Honor. There are a lot of others.
Was his expertise was in extracting or reviewing the information and how those were sort of obtained electronically and then simply guiding through, well, this is a transaction on this date that does this, which is not necessarily expert testimony, it's simply testimony.
No, but I believe it's a different expert that they have to do that does not have a report.
But is that expert testimony? Let's just say Mr. Kohberger on X date purchased a television. If for some reason that were to be.
If you needed some specialized
this
knowledge to
transaction
interpret a
demonstrates that this is
document,
Mr. Kohberger's account, this
or
is
to
Mr.
obtain
Kohberger's credit card,
information
and this is the
to
purchase
testify to
on
that,
Amazon. And it
yes,
was delivered to this
he would be
address
an
associated
expert.
with Mr. Kohberger.
Those are factual issues, Your Honor. It's when we get to what do they mean, or I put these things together and I've made this picture out of something. That when we get to opinion, I appreciate what the court's saying. It sounds to me like lists don't do it if you want to interpret a record. That's what we hope to hear. That's what I wanted to accomplish today.
Well, I think it's pretty clear. You cannot simply say an expert's going to talk about topic A, topic B, topic C, and then be able to give a host of opinions that fall within those topics. The requirement is to list what their opinions are and what they relied on to give those opinions. It's different than the civil rule. I don't think they have to give as much detail as the civil rule requires, but they have to at least give what the opinions are, and I believe what they reviewed, as I recall the rule off the top of my head.
I believe the court's about right. There may be another term or two in the rule that's specific, but I hear the court loud and clear. I'll point out one last thing and stop because I think I understand how the court interprets these issues and these rules. When you look at page 9 of the state's objection to our motion, and in the second to last paragraph, they tell you that they will continue to supplement their expert responses based on later discovery or whatever they decide to use. That whatever they decide to use has me worried. So I wanted to bring that up. I appreciate the court saying the court's going to apply the court rules and the discovery rules and follow the case law, and that's all we want. Thank you.
So that I'm clear, as the state's approaching to talk about this, in terms of supplementation, it's allowed. It needs to be seasonable, which means it has to be not just whole cloth new experts, for example, without good cause showing me why that's necessary. It needs to be seasonable in the sense of the timing of it based upon when the information was received, when it was determined it was necessary to supplement. And then obviously we'll look at that in relation to what may prejudice the other side in terms of the timing of it.
Certainly, I understand that. Their discovery deadline has come and gone. If something brand new happens, that would be a different issue. I assume we would deal with that then. It's when I read whatever we decide to use, that's very, very broad. That's it. Thank you.
So that's good. This seems like one of these motions that you just have to file to get the judge on record.
There's really much in dispute at this point. State's position, we've complied through our expert disclosures with Criminal Rule 16b7, as well as your court's scheduling order. State understands the framework that you've outlined. We were under the same impression, and I don't think that there's anything else in dispute.
Yeah, so let me give you a word of caution. Sometimes there's dissonance between what an expert thinks that they're going to talk about and what the lawyer understands from that expert. And the lawyer submits these disclosures. And I think it's really important that you be on the same page if you don't have a specific written report from the expert about.
This is such a good point. This judge, I don't know much about this judge's past legal history other than, I looked up some brief stuff, and he was primarily a civil attorney. He wasn't a criminal attorney before he went on the bench. And so if I recall right, he did a lot of med mal. And med mal is an area where you work with a lot of experts. Oh boy, do you work with experts, because you're dealing with doctors and you're dealing with opinion stuff, what's the standard of care and what's reasonable and so on and so forth. So dealing with experts, from my perspective, when I was doing trial work, was honestly like one of the most frustrating parts of the entire process. It can be like herding cats. It can be very difficult to be on the same page. And some of that is because of, budget limitations. You got time restraints. When I want an expert, I got to go to the court. I got to get permission to hire the expert, and then the court's going to give me a certain amount of funding. And so the only way I even know how much to ask for is because I've had to have a kind of preliminary conversation with whoever it is that I want to hire and give them the general idea of what I'm trying to, have them look at. And is that going to be something that they can potentially help with? And what is the workflow going to look like? What would you actually do with this information? And then based on that, how long is it going to take you, and what's your rate, and so on and so forth. So there's a lot of just straightforward kind of bureaucratic hassle involved in getting experts. Now, the state doesn't have to go to the judge in the court to get approval for that type of thing, but they got their own budgets to manage and stuff. And so there's similar kinds of pressures at play. So the lawyer's always kind of trying to minimize the time that they spend with the expert. One, to make it cost less. The more time I spend on the phone with the expert, the more it's costing me. And so anytime I'm on the phone with the expert, it really needs to be a value add. Like, I don't want to be on the phone with the expert having them, for the third time telling me the same thing they've already told me in prior conversations. That's not good. But the expert doesn't necessarily have that same incentive lined up. So that's part of it. The other part of it too is that we're the lawyer, we're not the expert. I don't know. A lot of times when I'm talking to an expert, I don't know what you need. I don't know what you need to look at. I don't know how you need to do your analysis. I don't know what kind of follow-up. Like, it's very important for me to take the direction from the expert. And so some experts are just better at that than others are, at being kind of the captain of the ship when it comes to that part of the investigation. So this judge having this insight, it tells me a lot about his previous practice and what he did. It doesn't surprise me at all that this is like a warning sign, because I bet he's been burned. I bet he's been burned a few times. Where he thinks, I'm calling this expert to talk about what's the scope of practice for, this particular position, and the expert thinks he's there to talk about what's the standard of care for this particular injury or something like that. And of course, like, there might be a lot of overlap between these types of subjects, but that's the kind of detail that lawyers will love to argue about around the edges. Your Honor, he's not testifying about the scope of practice. He's testifying about the standard of care, and standard of care wasn't disclosed. We saw some of that in Depp versus Heard. We saw some of that with Depp versus Heard, where pretty sure it was I can't remember her name now off the top of my head, but it was the pathologist that they had hired to talk about the injuries, because we found that in the unsealed documents. We got the expert disclosure and what that pathologist was going to testify to, and it was about basically, one, looking at the photographs of Amber Heard, and are these photographs depicting injuries that would be consistent with what you would expect from the incidents that were reported. And then the other one was, like, likewise looking at what she reported transpired. What types of damage would you expect to be on a person like that, who had gone through that type of incident? And apparently, a little problem with the disclosure. She was, like, only disclosed as a rebuttal witness or something like that. It wasn't disclosed as a primary. And so the Amber Heard, she just didn't call. She just didn't call her person that the pathologist was there to rebut. So it's beyond the scope of the disclosure. That's where lawyers, earn their big bucks, is around the edges like that. So yeah, he's done a lot of work with experts. He's been burned by experts. He's learned some hard lessons, and he's now passing on that wisdom. And that's, honestly, I like that kind of thing in a judge. Giving you a little word of caution here, young Ms. Jennings. I don't know how old she is. She's, just obviously quite a bit younger than the judge is. So make sure you guys are on the same page, because that can really be important.
What it is they're going to talk about, and make sure that you have supplemented and that you have provided a listing of the opinions that are going to be provided, and whatever else is required under the rule in terms of what that's based on. And I would encourage both sides to over disclose those opinions in caution rather than under disclose, because two things. One, you may find yourself in a bad position if you're not allowed to go into an opinion you felt you were going to be allowed to go to because it's not disclosed. And two, I don't want to spend half our day at trial with me saying, where's that disclosed at? And then
Mhm.
chasing the jury out while you dig through your thousands of pages trying to find where that is. And so the more exhaustive your disclosures, the less likely it is it's going to draw that objection, and the less time that we're going to waste at trial trying to find where you disclose that. And so I think sometimes, and I'm not saying you did that in this case, I think sometimes lawyers view this expert disclosure requirement as sort of tedious work that they need to get done in order to comply with the timeline, a requirement of the court, and then they sort of move on from it and forget about it. It's a dangerous tact to take. It is for the case, one of the most important things that you can do is to understand what the person is going to testify to, and give a disclosure of what they're going to testify to, what those opinions are, and to be looking at that as you're thinking about their testimony, as you should be doing certainly now, even though it's months away from trial, on a continuing basis. So I would really stress the importance of that in a case, particularly of this import. You know, and so don't feel like your job is done at this point, because I would suggest to you it's not. That you may consider needing to do some cleaning up and making sure things are more fulsome in the scope of those disclosures and what you're doing. The other thing, you know, I think you tried to do to a degree is you thought, well, we think this is fact testimony, but you know, in an abundance of caution, we're going to put it in an expert disclosure. Well, if you're going to put it in an expert disclosure, because in an abundance of caution, it could be viewed that way, I suggest you treat it that way in terms of what you give. Okay, thank you. And that goes to both sides. I haven't read your disclosures yet, so I don't know, you know, where that stands, but certainly goes to both sides. And I know that also, you know, the rules are different as to what the defense has to disclose necessarily and what the state does to some degree. And so I appreciate that.
Well, I think the court will anticipate that there's a rather large filing that contain a lot of actual reports. Your Honor, listening to the court's comments and understanding where we were a moment ago when we spoke, I feel like I must go through what their disclosures were because there are so many lists. My hope was that they would be limited because they didn't fulfill their disclosure requirement, and we did, and that put us at quite a disadvantage, not knowing what their experts would
Well,
say.
and if they supplement, you certainly can supplement based upon what they supplement, and I will permit that. And that's kind of the nature of the beast.
I do appreciate that. And should that become necessary, we'll definitely take you up on that, Your Honor. I want to make a record about some of their expert disclosures, though. All of the lab people, they have lab reports and notes. The Idaho State Police Forensics Lab, I better be really clear on that. Other than the wiggle room language, which would ask that they not be permitted to have any wiggle room language, the lab reports are fine, with the exception of one of the witnesses, Ms. Nowlin, that they've disclosed, and she's written no reports.
Is that the one they said is a rebuttal witness?
They said she might be a rebuttal witness, so I suppose now they know what our witness is going to say. I want to talk about the CAS report. The court's heard a lot about the CAS report. When I say CAS report, that's because that's what it's called. It's really a PowerPoint presentation. There's not any analysis in that. There's just, this will be my testimony. This is what it's going to be. Without much more, it's a picture, and it has some dots and some arrows. Your Honor, that needs to be cleaned up. We need to understand the analysis that went into coming up with those PowerPoint presentations. That's just not plain good enough. I would let the court know that the cell phone experts, there's wiggle language in both of those if the court hasn't seen that. Their disclosure number, that's Mr. Cox. That's a person that has not written a report at all. We have no idea, besides the state's disclosure, what that person's going to talk about. Agent Douglas that I talked about before, I don't think I need to make further record. There's a lot of documents, no analysis, no opinion stated. We put several of these in our pleadings, and so I won't go through all of them. I'm highlighting the ones that we're really concerned about. We have 3 that looked at digital data. The court should understand there's 60 some devices. There's digital data from third-party sources, and there are 3 people that are listed with just lists of things. It's Mowery, Tanzola, and Uri. They have lists of devices or social media accounts that they're going to talk about. That our expert told us would take 3 years to look at every bit of the data. So having no clue what's going to happen, I can envision exactly what the court's fear is when we get to jury trial, me wondering if this particular thing was ever disclosed. So I definitely needed to make a record of that. Further, with the lab personnel, there's a caveat that says they'll talk about other people's reports and other things that are outside of their report, in addition to some of the other wiggle language that I referred to. Your Honor, given that the state is now cautioned to think about those things and submit more, I feel like it's important for us to bring out that we have a right to confront the evidence that's
Yeah, I was just going to say, we talked about that before. They can't testify about other people's reports. That's a confrontation problem, and the U.S. Supreme Court has dealt with that head on, like not multiple times, like just recently again, I want to say in like 2022 or something like that. So no, they will not testify about other people's reports. They can testify about their own opinions and their own testing, but not other people's.
brought against us. Bryan has constitutional rights, United States and state of Idaho constitutional rights for a fair trial and to confront evidence. The expert disclosures are designed to advise us of what the state is going to do. Their disclosures were insufficient. I appreciate what the court said, but exactly what the court's worried about will happen if we don't have better disclosures. The jury will be in and out while we make sure that we have a clean record. We appreciate what the court said today, and we'd ask the court to order the state to comply or for the court to exclude anything that hasn't been disclosed so far. That's it.
So I'm going to give like both sides an example of what I expect. So you understand, there's been talk in this case about DNA. If somebody's going to talk about DNA and your intent is they're going to let the jury understand what DNA is, and essentially going to do a mini course on DNA, I expect to see that in expert disclosures. Not that they're going to do a mini course on the DNA. I expect to see the mini course in the disclosures, if that makes sense, in terms of what their opinions are, what their information is that they are conveying that is expert in nature. And so it really does behoove both sides to spend the time to do that. And that's the last I'll say about that. It is probably the most critical thing that you have to do at this point prior to trial, is to ensure that you have not just disclosed, but potentially over disclosed those opinions and what is required by the rule.
I'm going to go out on a limb and say that's not going to happen. I'm going to go out on a limb and say I don't think that's going to happen. It should, and it doesn't seem like the bar should be that low, you know? Just disclose what your expert's going to say, just have it prepared ahead of time. But I'm telling you, the trial prep, so much of it is done last minute, seat of your pants. Just one more of the issue of dealing with the experts too. You know, they're not always necessarily that responsive to the fact that you have deadlines. They have their own deadlines. You know, they got other stuff going on too. So this is what I would consider to be a pretty unusually stringent demand. Now, again, having said that, Idaho, their disclosure requirement is perhaps a little bit more stringent than it is in many other jurisdictions. Those of you watching Karen Reed right now, apparently you don't necessarily really have to disclose much of anything at all. Those of you who watched Indiana and Delphi, yeah, you get to just show up. If the defense hasn't taken your deposition, you just get to kind of show up and say whatever. If there's a report, it has to be disclosed, but there's no obligation to prepare a report, and so that's part of the game that gets played in jurisdictions like that. So some of this is probably related to the rules in Idaho, and that being the case, maybe these lawyers are used to that and expect that, and that's no big deal. But me hearing the judge put it like that in those types of terms, that he wants that level of substance, I mean, he's basically saying you need to have outlined their trial testimony. You need to have gone through their trial prep. You need to have that outlined, and that's what you need to hand over to the other side. And it's 8 months before trial, 7 months before trial. They haven't done that yet. I'm just here to tell you, they haven't done that yet. So this is why he's giving them leeway to supplement, because they're probably going to need to, if that's going to be the standard. very, very hard for me to believe that the prosecutor, with all the other things they have going on, the public defender with all the other things they have going on, I don't think they've prepped their experts 7 months ahead of trial. I don't think that's probably happened.
All right, is there anything else with respect to those?
Your Honor, is the court giving the state a new date to fix their disclosures?
I'm not giving either side a new date. There's, you understand, I think, what I expect. So you can choose to try to supplement those. If they are simply expansions of what it is that they've disclosed that are just being more fulsome, I'm probably not going to have a problem with that, given where we're at in advance of trial. And the defense certainly can look at those and decide that they want to expand or change or whatever their opinions are based on that. If it's whole new stuff, then you're going to have to demonstrate to me, new opinions, new lines, or even new experts. You're going to have to demonstrate why you didn't get that in the timeline.
Thank you.
Okay, is there anything else that we need to take up today?
Nothing from the defense.
I don't know whether we're going to have a Frank's hearing or not. I need to go and do that. But if you don't mind emailing some dates that you have available in the next, say, 3 weeks to do that in the event that we need to do it, I would appreciate that. Okay. All right. Well, I appreciate everybody's work, not just for the hearings this week, but in this case in general. And I know how busy you all are, and I hopefully have not taken more of your time than is necessary. Travel safe. Thank you.
All right, please.
Well, there we have it. So, I mean, what did we learn? What did we learn? Everything's the FBI's fault. The FBI did everything that we don't want to talk about. I mean, I guess I got that pretty loud and clear. They said they had personal knowledge of stuff, when it was convenient for them to do that, because they have to do that for purposes of an affidavit, but they don't actually have personal knowledge of it. That's just the same old game, same old game. So I'm glad that they focused. I'll just say it again. Glad they focused on the overbreadth, because that is a pretty strong argument here. It's a pretty strong argument, and it's a really common one to be bringing in the digital era. Starting to see it more and more and more. You get a warrant for somebody's cell phone, and detectives aren't necessarily, up on the case law. It's not necessarily their job to be. You'd like them to be, or at least, be guided by prosecutors who are up to date on the case law when it comes to doing these types of investigations. But they often aren't. They need to get something, and so they just think to themselves, well, let me just get a warrant to look in the phone. And this is kind of the downside. This, sometimes prosecutors get really used to the way that the judges are often just a rubber stamp. Here's a search warrant, flip, thrip. Here's, yes, the judge is like, I see that there are words on the page. I'll put my signature on it. No questions asked. Let them do whatever they want. And that's the downside to having the rubber stamp judge, is that if you don't actually know the rules, the parameters, the framework for what you're supposed to be doing here, you can get yourself in trouble. You can get yourself in trouble with that. And so they'll just write a warrant. Let me look at all the contents of the phone. And that's going to be a problem. Seen a couple of cases like that, and it's not good. It's not good. So it's got to be narrowed. It's got to be particular. It's got to relate back to the probable cause that justified you wanting to look here in the first place, because these aren't fishing expeditions. And the Apple warrant in particular, the Apple warrant, I don't know. I honestly don't know that they're going to save that Apple warrant. And so I will say, after having listened to all of this, I suppose I have a little bit more sympathy to the closure of the earlier part of the process, because I do understand what the judge was saying. Oh, there's potentially going to be talk about things that won't be admissible, at trial, evidence that won't be admissible at trial. And I mean, yeah, I think there's a very decent chance that that some of this digital stuff in particular, it's going to get suppressed. I think there's a very decent chance of that. And so if we can't use Bryan Kohberger's Apple account, massive amount of data in there. And again, this isn't even necessarily stuff. I've seen the argument so many times. Oh, well, if there's nothing incriminating in there, then you don't fight it and so forth. No, because police will go through and cherry pick stuff that makes it look incriminating. It isn't necessarily on its face, but you did some weird Google searches, you watched a weird movie, you read a weird book. I mean, you had a strange conversation. I mean, these things just happen, and then it gets pulled out of context, and now it's being stuck under your nose at trial. Didn't you text? I mean, look, not to always bring everything back to Depp versus Heard, but the out of context texts were just kind of a running joke in that whole trial, because they weren't really relevant to anything. They weren't, they weren't texts to Amber Heard. They were Johnny Depp venting to his friends, and they just, they became this whole big thing. He must have beat her up because months after, when they're in the middle of the divorce, he's annoyed with her and he's angry about her, and he's venting to his friends. So that's what the risk is. It isn't I mean, of course it can be. Yes, if he did commit the crime, there could be evidence in the Apple account that would hurt him. Can't rule that out, of course. It's just that, given the totality of everything else that we've seen, I'm not finding that to be likely at this point. All the reasons we've already talked about. So it's not, oh, they're going to discover all this incriminating stuff. It's find stuff that isn't incriminating, but they're going to twist it and they're going to make it incriminating. So that's why you have to fight it. But at the same time, like the judge is saying, if it's not coming out at trial, then it's just out there in public, and we've already seen the sideshow of this case and how things get seized on, often things that aren't even true. Hello, stalking. How many more times can we say? How many more ways can we say no stalking? He didn't stalk him. He was apparently never even at the house. Meaning, if he committed the murders, that day was the very first time he'd ever been there, as far as they can document. Seems unlikely to me. Can't say it's impossible, of course, but definitely seems unlikely. So I have a little bit more sympathy, I guess. I still don't particularly like it. I don't think it's legal. I still don't think it's legal. It doesn't meet the requirements. The Supreme Court laid out very specifically what the requirements are, and they talked specifically about suppression hearings. They know that suppression hearings could result in evidence that's not going to be presented at trial. And so they understand, yeah, there could be, public disclosure of that. Could be damaging. That's already accounted for in their analysis. And so he never gave a reason beyond that that justified the closure. Having said that, though, like I said, I can kind of understand his sympathy for why he might not want to disclose it. He already knows or has a pretty good idea, because it doesn't take very long looking at these warrants to know that. That's the thing about a warrant challenge. It really doesn't require it really doesn't require evidence. I mean, that's what's a little bit unusual, I guess, about having an evidentiary hearing on a warrant hearing at all. The execution of the warrant can be relevant, but when you're evaluating whether a warrant itself is valid, you are limited to the four corners of that warrant. You don't get to say, well, but police knew this other stuff or they later found out these other things. You are looking at that affidavit and you're looking at that warrant, and that's it. So the judge has already looked at those and he's already seen that language, you know, the entire account history, 2016 on. I mean, he's going to see that and he's going to know problem. So ultimately, I don't think it was a legal decision and I don't think it was right and I don't think he should have, but I understand that I think he believed he was acting in the interests of Bryan Kohberger. I can appreciate that, I think, a little bit better now after hearing some of this. So the lack of memory, I mean, I am curious to see if they're going to be able to make use of that at trial, just because one of two things is going to happen, right? The detectives are either going to be following the same pattern where they don't remember stuff that seems like it's kind of important things for you to remember, kind of details of your investigation. Was this investigation not important to you? Like, how much of a Keystone Cops routine do you really want to make this look like? Where the right hand really doesn't know what the left hand is doing, and the FBI is just operating in the shadows. Is that the impression of the investigation that you want to give the jury? It probably isn't. And so then what can you do? Well, you overcorrect, and then you go to trial, and now you remember everything. But now you're contradicting when you swore in your testimony before that that you didn't remember any of that stuff. It's a fine line. I mean, it's got to be a pretty direct contradiction as far as like specifically what's being asked for them to be able to use that. They can't just be like, well, the tone of your answers was very different in the prior hearing. That's not going to be, that's not valid. That's not good impeachment. But certainly we, the audience that's watching, will notice if there's been a difference. Suddenly there are these crack investigators. They're on the ball. They got all their notes. They got their lists. All the details at their fingertips. That'll be interesting to see, won't it? Don't know how that's going to play out. They definitely seem to be going full speed ahead as far as this trial date in August. Not seeing any good indication that anybody is inclined to try to change that. So also good to know, prepare accordingly. I will be prepared. The Bearcat, I still can't, I kind of can't get over the Bearcat. They needed a freaking Bearcat. They needed the Bearcat because he was walking around the house in kitchen gloves. I understand. The judge says that's not all they had. That's not all they had. All right, we'll wait to trial for the details. It's fine. But it definitely just continues to not sound like they really have very much. Bill Thompson did make a comment about you know, some of those details are inculpatory, and of course didn't really tell us what they were, but that is a little bit of a change of pace from Bill Thompson, right? We've heard a lot of those types of representations about the status of the case from the defense, right? That the whole thing has been reverse engineered from the IGG, and when we first got that information about no connection with the victims, no DNA, etc., no response from the state on any of that. So this is really, I think, the first time I can remember that we've gotten a little bit of pushback from Bill Thompson when it comes to those types of representations, getting it out there in public. Well, there was incriminating stuff happening in the house in Pennsylvania. So we'll find out what it is. Is it going to amount to proof beyond a reasonable doubt that he committed these 4 murders? I'm skeptical, but I remain open to the possibility. Mowery, really, I mean, both of them, Payne and Mowery, I remember them from their testimony before. It seems pretty consistent that they just give this impression that they don't care. You know, when you show up and you don't know, you don't remember details of your investigation. I understand why they do that. It's because they don't want to be pinned down, and especially on things that they're just assuming. A lot of times when defense is asking the question, we're going to be defensive about it because we're just going to assume, you know, they're trying to lead us down the primrose path to something that's not good for the case. But it's just not a good look. It's not a good look with a case like this, because it makes it look like you couldn't be bothered. You couldn't be bothered to pay attention to what was going on in your own investigation, to what other people were doing, especially Payne. Especially Payne. He's the lead. He's the lead detective. And so if the buck doesn't stop with him, does it stop anywhere? I just wonder. I just wonder what that's going to look like when it gets to trial. Is there going to be a remarkable transformation in these witnesses? Or are they going to continue to give this impression of, well, this is just, you know, this is a horrible murder. Okay. This is a crime that was so bad it caught the attention of the entire world. And are you going to be acting like, oh, it's just another day, and so we just kind of did our thing, and I don't know. I mean, I don't really remember. It was just comes across as you think it's not really that important. Well, I don't think we have any hearings on this coming up really in the short term. Do we? I think this is pretty much it. So we'll wait for the ruling on the Franks. What are we going to get? What are we going to get on the Franks? Now, there was the interesting little exchange yesterday when Ms. Jennings was giving her presentation, and she was arguing about facts, and he's asking her, where did those facts come from? And she's like, well, they're in my response. And he says, I was afraid you were going to say that. And the reason why is because it's just not a good idea if the state has to add facts. They're creating a dispute with the defense. And so the posture with the Franks is that the defense has a burden to show that it's justified, and that's what they're presenting evidence to establish. And so the best strategic position most of the time for the state to take is to just assume that what the defense says is true, and address it accordingly. And it seems like they really could have done that in this particular case, if for nothing else, because of the reason that that Judge Hippler gave. Hey, throw it all out, and it doesn't matter. We still have the trace DNA. And for everything but those, you know, WSU and apartment, you know, the Washington state warrants, that's going to probably be okay. That's going to probably be okay. But so if you don't do that and you start adding in new facts, well, now you've created a factual dispute. And when you have factual disputes, that's when they got to hold a hearing. And so it seemed like that was a moment where he's kind of like, he'd already warned them. Explicitly, he'd already warned her. If you bring in additional facts, I have to give them a Franks hearing. And that's the reason why, because she's putting things into dispute. So he has to take evidence to be able to resolve the factual dispute. So he'd already kind of warned her. And then, you know, she continues with her argument. Yeah, it was stuff I added. And I was afraid you were going to say that. So even though, you know, he hasn't signaled here what he's going to do with the Franks hearing, you just asked for the dates just in case. But that's pointing in the direction of doing the hearing. It's pointing in the direction of doing the hearing. Frank's hearings are very unusual, guys. They don't happen very often. You don't even really ask for them very often, honestly, because you just, you know, normally when the police lie about stuff, they're, you know, too good about being able to cover it up. But I did have one. I have one I remember where I asked for a Frank's hearing, and the issue was that the police had gone and gotten a warrant for this marijuana grow. And the problem is that so according to the warrant, the officer is like in the neighborhood for some unrelated reason, and he's walking by the house, and of course the overwhelming smell of fresh marijuana, so he smells it, and based on that, you know, decides to go get more and go in the house. What he doesn't put in the warrant is that law enforcement, they already know that this is a licensed legal grow operation. It's a medical grow operation, and they know this because just the prior month, the owner had called them because people had been trying to break in and trying to, you know, steal, trying to rob the grow. So they already knew this was a legal licensed grow. It wasn't something that they were unaware of, but they didn't include that fact in their affidavit. And in that particular case, I did not get the Franks hearing because they're like, well, they didn't think that was material because just the fact that it was, you know, presumably legal doesn't mean that there couldn't have also been illegal activity happening or something like that. I still to this day don't really get the reasoning behind that, but there was some case, as I recall, there was some case law that had already come down deciding it. Seems to me like kind of a significant factor in terms of whether there's a reason to believe there's illegal activity going on when your basis is I smelled weed. Yeah, and weed is legal to be there. And this again, maybe it had to do, I don't think it did though. I was going to say this goes back to that whole double standard where we know all of the information of our fellow officers when it's convenient for us, but not when it isn't. Not when it isn't. If it's not a knowing omission, then we can just be willfully blind to that type of thing. I don't think that was what it turned on though. It was a long time ago. This one was probably at least 10 years ago. So you don't get them very often. You don't get them very often either because they're like, well, the officer wasn't really lying or it wasn't really misleading, or, you know, because they use wiggle words and stuff. Or because they say, well, it wasn't really that important. It wouldn't really have changed the magistrate's mind. Not really that material. And so, you know, that's kind of my, if I were in Vegas putting odds on this, I think you have to say, no, they don't get a Franks hearing because the odds are just so strong against it. But there was that little signal yesterday. I was afraid you were going to say that those facts that you're relying on in your argument, those were extra facts you submitted in your response, because that creates a factual dispute. And you'd already warned her, you've got to give him a hearing if you're going to do that. So maybe. I'm still going to say probably not, but I'd say odds are probably better than they are just on average. You know, on average, I'd say almost never get a Franks hearing. Getting a little bit more of an impression of the judge. And I don't dislike the judge. I don't dislike the judge at all. He's very direct. I like that. I like direct in a judge. I like when they just go ahead and tell you what they think instead of like sometimes judges will kind of try to, work around things. They'll try to be Socratic with you and stuff. And I don't really get that impression from this judge. I mean, he might have that tool in his kit, but he doesn't really seem like he's flexing that with the lawyers. He just knows what he wants to know, and he's going to ask it. He's going to ask it directly. I really like that in a judge. Like I said yesterday, I find that kind of thing helpful. If I'm wasting time with what I'm saying and it's not getting you what you need to know to be able to decide in my favor, then by all means, cut me off as much as you want. Put me on track. Help me help you decide for my client. So that, I think, is a positive attribute. Say I really have any problems with how he's conducted things so far, other than the closing. The closing the courtroom, closing off that hearing. Don't like that at all. Don't think that's legal. But I don't hate him for it, because I do kind of understand why he thinks he was doing the right thing. So I can at least kind of respect it, kind of appreciate it. But by and large, he seems to be very thoughtful. He seems to be very smart judge. The impression I'm getting. I mean, he gets a nuance, in and out. He knows right how to get to the heart of the issue. He took Ann Taylor right to standing with the IGG argument. Right to standing. Yeah, that's the issue. That is the critical issue. And that's what Jay Logsdon had to get up today and address, because Ann Taylor just never got there in her presentation. He's got to argue, well, it's not a standing problem because you, an individual, have a shared interest in your shared DNA. It's a tough argument to make, but it's really the only one that there is to get around that problem. So very sharp, very incisive, but that can, like I said, that can also be very dangerous. That can also be very dangerous. It can be very helpful, and it can be very dangerous. So you just got to know. You got to be very intellectually honest about your argument with a judge like this, because he's going to ask you that very direct question. And if you're being intellectually honest with yourself, you'll already know. Does answering this question benefit me or not? Is it helpful to my position or not? And if it's not, then you better have prepared for it, because he's not gonna play nice or pussyfoot around or try to avoid putting you on the spot. He's gonna put you right there on the spot and let you know he knows. He knows that's what this issue is all about, and this is where the problem is. So I kind of like that. I kind of respect that. So I am definitely interested to see more from this judge, especially get some written rulings from him. I'm looking forward to some written rulings, especially on the suppression stuff. I want to see how his mind works. We get just a little hint of it. He's obviously not a real active judge. When he does participate, he's got a certain style of doing that. But most of what he did was kind of sitting back. That suggestion, man, coming up with that suggestion. Well, they had access to the affidavit. Oh, I really, really, really wanted the defense to close that door. Okay, maybe potentially they could have looked at it, but you don't know that anybody actually did. So important to establish that, and they didn't. I suppose defense can kind of always have the argument that that's burden shifting. It's the state's burden to prove that they did, and the state didn't bother to prove that. They just proved that they could have, but not that they did. But would have been better to just close that door, I think. So yeah, I enjoyed these hearings, even if I don't know that we necessarily got a lot out of them. Okay, we got a little bit of new information. The stuff about DM and her interviews, that was pretty new. The dog, hated what I heard about the dog. The Bearcat and the snipers in Pennsylvania. Yeah, I mean, I knew from Jay Logston's description that it was a pretty over the top raid for a quiet residential neighborhood. But yeah, didn't really know those details. And then some of these things about the search, the phone processing, they had his phone, they extracted his phone, some mystery FBI extracted his phone without a warrant. Why did they do that? I mean, they do it because they think they're going to get away with it. And they think they're going to get away with it because they're the feds and they can't be compelled. So that's one of the kind of disturbing things about these task force, style investigations when the prosecution is taking place in state court, is it's just an opportunity to launder a whole bunch of misconduct. They can do it. They don't have to disclose any of it. It's TUI. They get to hide behind TUI. And their sovereign immunity as agents of the federal government, a separate sovereign from the state. The state judge can't compel them to do anything. So they don't have to disclose any of it. So that's why they do it. But boy, isn't that alarming? And I have to wonder too, is that then going to get explored at trial? Are these kinds of questions going to be asked at trial? Who did the extraction? There's always like a little bit of a trade-off when you're in a trial situation and you have to do that. If the state is state's calling FBI agents to the stand, to what extent are you putting off the jury by asking them things that they may not necessarily understand to be relevant, or they may think you're just trying to make them look bad, especially if you're getting negative answers? I don't know who did the extraction of the phone. So some of that you just kind of have to let go sometimes, which can be very frustrating, and that's how the system perpetuates, right? That's how they get to keep doing it, because there isn't really any good, effective way to hold their feet to the fire over it. But yeah, that's kind of alarming. Actually went in and extracted the phone without a warrant. They know perfectly well. They know perfectly well you need a warrant to extract the phone. And so we're supposed to just believe, no, nobody looked at it. Of course, nobody looked at it. Why? Because nobody's going to admit it. So we're supposed to just believe that. Why would they do it otherwise? You're going to get the warrant. They did get the warrant. It's easy to get the warrant under these circumstances. So why would they do it if not because they wanted to look at it first? But that's just part of the fiction, and I think the judge is gonna go along with that. It's convention. It's convention. Your law enforcement officers, they're credible, they're upstanding. You give them every benefit of the doubt that you do not give the criminal defendant. Well, guys, I think that's all my kind of independent thoughts about this. I did go through most of my scratch paper, but I had enough paper, so I have my notes I'll be able to take home with me. Let's go ahead and go through some of your comments and questions here. Mad World, so glad to see everyone again. Also to all the Alessi lovers, Attorney Karen Reed, he's mine. Oh my God, Alessi is a G, man. That guy came yesterday. That guy was banging. He's a very impressive attorney. He's obviously extremely intelligent, mind like a steel trap. Very good felicity with the information and the law, and being able to navigate on his feet and respond to what the Commonwealth is doing. That guy is an excellent lawyer, and from my perspective at this point, very much the star of the team. Obviously not saying that Alan Jackson and David Yannetti are, bad lawyers or anything like that. Of course not. They're excellent lawyers. But Alessi, he's in a different league, in my opinion. Mike Dorado, you have been so missed. How about those Eagles? Oh, fly, Eagles, fly, baby. Fly, Eagles, fly. Yeah, I mean, the life of a Philly sports fan, it can be a little bit rough. We'll see how this goes, but this is the chance for redemption, right? Last year wasn't real fun. Last year wasn't real fun with this matchup. We'll see. We'll see. We got Saquon Barkley now. I mean, we got Saquon Barkley, and that man's been working some magic. So let's see what they can put together. But yeah, very exciting time to be a Philadelphia sports fan. The crypto tax lawyer is here. Welcome back as a member. Good to see you. And Andy Kopsa is here as a YouTube member. Thanks for joining us, Andy. Andy reached out to me on Twitter the other day. She's a journalist and has some ideas about some very interesting conversations that I think I would really enjoy having, because there is this big conflict in the modern day and age with how much media is out there, and the availability of information and the speed of the news cycle, all that type of stuff. There is a real conflict potentially between the right for the public to know what is happening in their courts, to know what their government is doing, and to know the details of prosecutions that it's carrying out in our names and on our behalf, with the potential to poison the well and make that whole process harder on the defendant than it needs to be. I mean, one of the big challenges and the big problems, see it time and time and time again, certainly saw it in this case. You hear everything about the investigation, you know, everything that law enforcement is thinking, and then they do their arrest and they have their press conference at the arrest, and here's how we know, we're gonna nail this guy. We're so proud of ourselves for having solved it. All these prejudicial things, and then go into court, and everybody's got to shut up. And the defense never gets a chance to counter any of that. And that's part of why the process is supposed to be public in the first place, as far as my opinion is concerned. But it is. There's no question. There's no question that can be challenging from a practical standpoint. So anyway, we should definitely have that conversation sometime. I think that would be a lot of fun. Mary Holt is a YouTube member. Welcome, Mary. Shards of Words. Unable to join via sending support. Well, thank you so much for your support. I really do appreciate it. And I think I saw you in the chat trying to get sorted on iPhone. Apple doesn't make memberships easy on the iPhone. I don't know why that is. But we do have a lot of folks that very generously gift memberships a lot of the time too. So hopefully maybe you'd be in line for one of those at some point. Mad World, like the walkthrough of the Delphi report, by the way, Andrea. Well, I'm glad. I had some time and I'd read the motion, and so it was fresh in my mind, and I just thought, hey, doesn't need to be all like flash and glam and stuff like that. I mean, here we are in my hotel at the south end of the world. It's really about the substance, right? So I'm glad that you enjoyed that. CB's SW2 is a YouTube member. Welcome, welcome. CT Girl 5150, so glad to have you back. Well, thank you so much. I sure appreciate that. It is good to be back. It is good to be back. Sometimes when I go quiet, it's just a lot of times it's because I'm really not sure what to say. Especially coming out of a trial and an experience like Delphi, it was just so intense, and so much happened, and I had so much to say at the time, and then it's over. And what do we got now? We're waiting for the appeal. I mean, we had of course this motion, and we'll see what happens with the motion, but I'm sure I'm not alone in not being very optimistic that much is going to happen with the motion. So a lot of times I don't necessarily have a lot to say, and I don't want to be someone that just gets on YouTube to yammer, you know. I want it to be I want it to be because there's a point, there's a purpose. Um, X is a little different. I'll do just like, you know, quick takes and stuff on X because that's really what the format is. That's kind of what it's for. But to get on YouTube, I really want there to be a reason for it that's beneficial for everybody. So I'll just give you an example. Like I've been following the Blake Lively the Blake Lively case against Justin Baldoni. I read that. I read his case against the New York Times. I've had some kind of quick takes on it, but I don't really have an overall impression yet. And a big part of that is because so much of it is just kind of like gossip, you know, oriented, you know. Okay, saw the complaint, saw the counter complaint, but there's, you know, so much that happens in terms of positioning in a lawsuit. And so what's the overall point of that case yet? I don't really know. I don't really know. I don't necessarily have something I want to say about it yet. And so there's already lots of people out there talking about what's actually happening, you know, giving you the blow by blow of the events. So you don't need me for that. But I'll at some point I'll figure out, you know, why that case matters and what I have to say about it. I do actually have some ideas already. I'll probably put it up on Substack. I'll just give you a little preview though. I got some thoughts about the male feminism, the male feminist angle that relates back to some work that I did in the Title IX context, right? The universities and the complaints, the processes that they have, their tribunals and stuff for adjudicating complaints, and just the things that I saw through that process, and some kind of connections, some relationships I see kind of bleed over into this complaint, and perhaps the Me Too phenomenon a little bit more in general. So anyway, sometimes it takes a little bit of time for things to ferment a little, get ripe. But once I have my thoughts all put together, I definitely enjoy being back, and it's inspiring to me too. So thank you so much for that nice comment. I do appreciate it. Mad World, thanks, Andrea. Mods and chat, felt like I've had a huge hug today. That's exactly how we want these streams to be. We want this to be a good place to hang out and to share good ideas and express our joy when somebody on the record in a court proceeding talks about the panopticon. I'm so glad he went there. What a moment. I feel like more vindicated by that than almost anything else that's happened to me recently. Oh, the joy when I heard that word. Loved it. Popperski, thank you, Andrea Burkhart, for working as a defense attorney. It strikes me from the UK that USA's dirty little secret of rife corruption makes the job of a defense attorney truly a laudable profession. Well, you know, we can get a little cynical sometimes, and I'm certainly not immune to that. And I can also, you know, sometimes be a little prone to overstating, you know, how bad the situation is. I don't want it to sound like, you know, every investigation is corrupt, every law enforcement officer is bad. I don't think that. I've been on record many times talking about good cops that I know, good departments that I've worked with, and good investigations and stuff like that. It's a very, very important role that they play. But with so much at stake, the tolerance for corruption and for shenanigans should be extremely low. And so it's the fact that it's not that is so frustrating. The fact that so many people, including judges, including courts, seem to be willing to have an ends justify the means philosophy as long as they figure they're only going after bad guys, and that's all that's, you know, being affected. Then we don't really care. We don't really care about what lines they cross, what rules they break, or whatever to get the outcome that's just you know, in their view. And that's just, it's such a damaging perspective, because the integrity of the institution is what is so critical to its reliability. If the people aren't guilty and you're using these types of you know, tools and stuff against them, these rule breaking things like that, you increase the risk of injustice, because you run the risk of, yes, we're going to cherry pick the little things that make you look bad, and the jury has already got this, you know, attribution idea that, you know, just by virtue of you being accused of something sitting in a courtroom, you're probably bad and you probably did it, and we're probably going to convict you. It just really really increases the risk that the system isn't producing the type of result that it should. So it's a very frustrating profession a lot of times for that reason. I guess if sticking with it makes makes it laudable, then thank you. It is, I guess. But yeah, it can be very frustrating. Cyan, if the state just can't get the IGG reports from the feds, what's the remedy for the defense? There isn't really a remedy, and that's the point. The remedy is suppression. The remedy for non-disclosure is suppression, but the state has already said, well, we're not going to use it. And so that's how they've kind of worked around this problem with the FBI being able to do whatever they want, and do it as opaquely as they want, and do it you know, as not on the up and up as they want, because the only recourse is for the state to not use it at trial, and the state isn't going to do it anyway. So that's how they're able to keep it under wraps. Adam Limprello, Andrea, the Fourth Amendment case law suggests that the DNA is admissible. Given that, could the subsequent searches of digital information be justified under the search incident to arrest doctrine? This is a good question. So no, it's not going to be justified as a search incident to arrest, and the main reason why is because the search incident to arrest is a fairly limited doctrine. The most recent like big case on this, Arizona versus Gant. I can't remember now exactly when it was. It's been a few years now. But previous to this, the search incident to arrest doctrine basically says that upon arresting somebody, you, due to interests of officer safety and the preservation of evidence, you have the right to search the person of the arrestee and the immediate area of his surroundings where that person might be able to access a weapon or you know, evidence that has the potential to be destroyed. So that rule was announced in like the 1990s, I think. I don't remember off the top of my head the names of the cases, you know, and how that doctrine grew. But it started with houses. Was it Schimmel? It started with houses and a search of a house, and then it expanded to being able to use that in automobiles. So Arizona versus Gant was a case where a guy had been arrested, and I don't even remember what it was for. I don't think it was for anything particularly serious, but he was arrested, pulled out of the car, handcuffed, thrown in the back of the patrol car, and the police then go in and search the patrol car under the search incident to arrest doctrine, right? He had been recently in that car, and they looked in the, you know, pretty much the entire interior of a vehicle is like within your immediate proximity. And the Supreme Court said, no, we're not going to allow that anymore, because you're getting away from what the initial justification was. The initial justification was always the person might be able to get a weapon, or the person might be able to get evidence and destroy it. And once you've removed them from the car and handcuffed them and secured them in your own patrol car, that's no longer a risk. So you don't get to bootstrap an evidentiary search under these types of considerations in that framework. So the search incident to arrest exception is very limited for that reason. And because of that, it does not generally extend to contents of a cell phone. So yeah, they might be able to take your cell phone out of the car and secure it, but they typically have authority to do that anyway. They can secure property for that they have, you know, probable cause to search for the time that a reasonable length of time to be able to get a warrant to search it, and that's a Terry justification. So they can take your phone and get a warrant, but no, they can't. They can't justify going into your digital stuff, at least under Gant. Once that's no longer, you know, no longer in your possession, and you're not in a position to be able to access it and, like, say, delete evidence or stuff like that. So that is an interesting argument, though. It's an interesting idea, especially now as we're getting into more of an era of cloud-based, you know, cloud-based forensics, cloud-based information, because I don't necessarily need my phone to be able to go in and delete things, right? I could do it. I could do it remotely. I could potentially do it all the way from the far ends of the earth. Not that I'm going to. So yeah, that's an interesting idea, and one to maybe keep an eye on, because as I've said, the law typically is way behind the technology, and I can't think off the top of my head of any sort of effort to apply the search incident to arrest to cloud-based information. But I could see the way that the government could potentially assert that those interests are furthered by a search like that. S. Qwerty, you're a great lawyer and educator, but I also wanted to give you props for your photography. You have a great eye. Thanks for sharing your adventures. Thank you very much. I like sharing my photographs. Back in the day, I wanted to be a professional photographer when I was in high school. I thought that was a road I would go down. In fact, I had a path. I had a path in my life. One of those, you know, you could go this way, you could go that way, and it was right before I went to law school. I applied to law school and I applied to film school, and I had both options available to me, and I chose the law school mainly because they weren't going to bankrupt me to get the education, and it would have made more sense to bankrupt myself for a legal education than a film one anyway, I think. But yeah, just that fork in the road that I took. So photography, still a hobby of mine, but glad that you enjoy those. I enjoy taking them. Gen 7. Andrea, have you read Blind Justice? A former prosecutor exposes the psychology and politics of wrongful convictions by Mark Godsey. Thank you. So I have not read it. It's on my, I have a hold for it in Libby. I've been waiting for that one. The one that I'm currently reading right now is Saul Cossen's, Dr. Saul Cossen's book. And the name of it's escaping me off the top of my head. I should look. Hang on. Let me just grab my phone and I'll tell you right now. Duped. The book is called Duped, and it's about wrongful conviction. It's about confessions. It's about false confessions. Saul Kossen is a psychiatrist who's done a lot of research in the area of false confessions and the effect that they have, you know, in the criminal system, why people do them, all that type of stuff. It's a really fascinating book. But no, I have heard of Blind Justice, and I am very eager to read it. So thank you for bringing that up and sharing that with the rest of the audience. If I'll just put out there is, would folks be interested in, like, talking about books? I don't know. I bring up books sometime. I do. I kind of go like in waves with my reading. You know, sometimes I read a ton, sometimes I don't. Sometimes I'm, you know, busy doing other things. But I would characterize myself as a reader, I guess. And I do tend to like a lot of nonfiction. I know it's super nerdy, but it's just what I like, you know. So sue me. But if people are interested in that type of thing, I'd be more than happy to talk about it. A book like that, I think, could be interesting to have a conversation about. Becca, Wisconsin, with a super sticker. Thank you so much for that, Becca. Really appreciate your support and your support for the channel. Well, guys, that's all we got for today. So another intriguing hearing. Gotta wait and see what he comes up with. But maybe when we get the ruling, I'm especially interested in the motions to suppress rulings because I want to see what his reasoning is going to look like. I think this could be potentially a good thing to go over in a live stream just to see how he thinks and to talk about how he thinks. Definitely with a ruling like that, we're always going to be looking at it for an appellate standpoint and you know, how is this going to stand up? What's this going to look like from an appeal type of framework? He's a smart judge. I wouldn't be surprised at all if he kind of knows some of the tricks to be able to insulate his rulings. So I'm going to be looking out for that type of thing. But otherwise, guys, I don't have anything imminent on the horizon. We'll just kind of be waiting and seeing how things unfold as far as the cases that I'm following. So just to recap, again, I'm watching Karen Reed. That's just had a hearing yesterday. I did watch it. I didn't live stream it, but I did watch it. I am, for those of you interested, predicting we are not going to have Richard Green excluded. The motion is not going to be granted. The Judge Bev did sign an order saying she's not requiring an evidentiary hearing on the Daubert motion, and for me, that's the tell. That's a massive tell. You're not going to exclude the evidence without having the hearing because it's prejudicial to the defense's, you know, defense, their ability to present a case. And so excluding it without a full record of why it's improper is just you wouldn't do that. So I think she's signaled that that motion is going to be denied. But otherwise, we're just kind of waiting to see what other motions get brought in that one, and waiting till we get to the trial date again. I know the appeal is still pending on that. I've kind of already given my opinion on that. I don't think the appeal is going to be successful. The case law is very much against them on the double jeopardy issue. So unfortunate. I mean, obviously, a lot of things I think could have been done differently and maybe should have. But as far as does the law compel them? No, I don't. I don't think they do. So wait and see what happens with Karen Reed. Waiting and seeing what we get next from Bryan Kohberger. Kind of still letting my thoughts coalesce a little bit about this Blake Lively and Justin Baldoni thing. Oh, and then of course there's all this Diddy stuff. Oh my gosh, the Diddy stuff is like hard to keep up with. There's been a superseding indictment, so that kind of suggests I don't trial on that's supposed to be I think in June. I'm very skeptical it's going to happen that fast. I could be wrong. But kind of wait and see how that one goes. But on that one, I've honestly been a little bit more interested in the kind of side positioning with Alex Spiro, right? Jay-Z's attorney, and the kind of war that he's trying to wage against Anthony Busby, who is the attorney for some of the accusers of Diddy, and he's the one that filed the first complaint that names Jay-Z as a co-defendant. So there's just been kind of a lot of little back and forth about that, and I'm a little bit behind on it. I got to catch up. But last time I checked, there was a little bit of a question about did Busby kind of mess up and not get himself admitted to the Southern District of New York bar? That might be a little bit of a problem. So I need to look into that a little bit. But those are the cases I'm continuing to keep an eye on, guys. And if other ones come up, you know, as they come up, they may or may not catch my interest, and I may or may not have things to say about them. Sorry, I can't be a little bit more committal with you guys about when I'll be here and what I'll have to say than that. But I definitely am at the point where I'm getting some more ideas and some more interest in talking about some of this ongoing stuff. So in the short term, however, I am leaving on a trek tomorrow. The reason I'm down here in Navarino Island and Puerto Williams, the southernmost city on the planet, is I'm going on a big hiking trek. There's this mountain range called the Dientes de Navarino, the teeth of Navarino. We flew in, they really do look like teeth, guys. Holy cow, like it does. It really looks like teeth. So I'm going on a big trek up there. So I'm not going to have cell service, nothing, completely off the grid. You know, carrying my my pack and sleeping on the ground and all that good stuff, the stuff that really really feeds my soul. And just because it's been my kind of luck on this trip in Chile, we're going to have some weather change according to the according to the report. We might get some rain. We're supposed to get some cold. We might even get some good like 40, 50-mile-an-hour wind gusts. Exciting, guys. Let me tell you, nothing makes you feel alive like trying to hike yourself to where you're going to sleep and eat through 40-mile-an-hour winds. Whoever said being alive is supposed to always feel good all the time? You know, I'll just my last little story that I'll tell before I check out here. But I came down here last year to Chile. Some of you may have saw when I was doing that. And I did a trek at Cerro Castillo. There's this circuit that you do. It's a 4-day circuit for the most part. It's about what 50 some kilometers, maybe 60 kilometers. So it's not super long. It's not super hard in that sense. But the terrain was very, very, very difficult. Like you're having to like climb up waterfalls, you know, not so much like hand over hand stuff, but just a lot of like just bad surface, you know, rocks and things like that that are real hard to walk on, you know, heavy pack, all that stuff. So it was hard. It was a little bit harder than I expected it to be. And you know, one of the things about just hiking around and being outside and stuff is it's such a be here now type of activity, right? You're not on your phone, you're not watching the TV. I mean, you can let your mind wander if you want to, but a lot of times it's just you're not. You're just in that empty kind of Zen space. You're looking around. You're watching the trees, the wildlife. You're feeling the breeze and the sun, all that good stuff. You're just really in the moment. But when you're on a trek like that, that's hard. The moment kind of sucks sometimes. And so I had this moment where I was kind of having this conflict. I had caught myself like mentally like being ahead, you know, I can't wait till I get to the campground. I can't wait till this stretch is done. I'm like, no, Andrea, be here right now. And I kind of had this realization, this recognition that like sometimes the be here right now means you do have to lean into the suck, right? It sucks. And you have to accept that. That's the good and the bad. Like the be here now is not all blissful stuff, guys. Like sometimes being here right now really sucks. So I'm like, I'm just going to give myself permission to really lean into the be here now at this moment. And so I did. And I in my head had this kind of very brief mental tantrum, like literally like a toddler tantrum, screwed up face, you know, turning purple. I hate this. This sucks. I can't wait to be done. And it was just so funny to me, even at the time, even thinking about it, that I just kind of cracked myself up. And so I had a much better hike after that, because every time it sucked, I just got to think about how funny it was to kind of, you know, be in that toddler tantrum mental state. So I found that to be a helpful perspective when it comes to getting through hard times and stuff like that. So hopefully we don't have too much of that kind of suck on this trek, but it is possible. And so if it does, I just hope it's really funny. We got one more comment that came in here. Jeff H. Coffee's on me, Andrea. Thank you for your great lives. Thank you so much, Jeff. I will definitely help myself to a nice café con leche. One of my favorite things down here. They make wonderful coffee down here in Chile. One of the things I love about Chile, they are so into their sweets, guys. They love their sweets. Like you go into the grocery store, and I mean, I was shocked at like the proportion of cookies to, you know, normal food, meat, produce, eggs, things like that. Massive amounts of cakes and cookies and all these different types and stuff like that. They don't really do breakfast buffet here unless you're in kind of an American catered place. That's a little bit more of an American tradition. Breakfast is not really a major meal in Chile. It's usually like just something light, some fruit, a little bit of bread and cheese and meat, maybe like, you know, salamis, things like that. But I've been staying in a couple places that that have a breakfast buffet, and they'll have like cheesecake at the breakfast buffet. So anyway, the love of sweets has like translated into wonderful coffee shops and good cafe con leche with like a nice pastry and things like that. Oh, pie de limon. Oh, they make this wonderful pie de limon and like raspberry, like they'll have like raspberry in it. It's amazing. I'm down here now in Calafate country. Calafate is a wild bearberry, and but it tastes like a blueberry, kind of. Um, it's like the closest thing I can compare it to. It certainly looks like a blueberry. It's just a little dark blueberry thing. It's just on a very spiky bush. So anyway, lots of stuff with Calafate down here in this part of the country, including, oh my gosh, Austral Cerveza. Guys, this is like the beer that you guys are missing out on in the rest of the world because I don't think they export it anywhere. I was looking, I even emailed the company because I wanted to find out, is there anywhere in the US where you can get this? They don't export it to the US. And I'm sure a big piece of it is just because I dealt with alcohol licensing and stuff like that in my previous life, my old practice, to know like what a hassle it is to get through that, but particularly the labeling requirements. They would have to like, I'm sure they would have to design a whole new, label, can, bottle, whatever, and they have to go through the whole process of getting that approved and so forth, and it's just a big upfront investment in being able to export. So they don't export anywhere to the U.S. It is the best beer, and I bring it up because one of the really good ones that I enjoy is the Calafate Ale. It's excellent. It's so good. They make this hoppy lager. I love it. I love it so much, and one of the reasons why is because America has just gone way off the deep end when it comes to hops in beer. Like they're so immoderate with it. It's gotten ridiculous. Like you get an IPA, and like the right amount of hop is good in a beer because it gives you a little bit of citrus, a little bit of bite. But we just overhop it to the point where it's astringent and it's bitter, and it's just not good. It's not balanced. It's not a good beer. This hoppy lager, it's perfect. They like hit the perfect balance. Oh, it's so good. Anyway, those are just some of the things that I love about Chile, and that I will continue to enjoy as long as I can while I'm down here. Mad World, appreciated your Nat Geo comment on a pic, non-selfie I commented on, by the way. Yeah, I did. I wanted to be a National Geographic photographer when I was in high school. I was big into photography. They had this amazing dark room at my old high school, and so I learned how to do all my own processing and things like that. And I got super into it. I had my little corner of the basement that I made into my own dark room. But then I watched a documentary on National Geographic photographers and what that's actually like. And I mean, in many respects, I think it's like any job where they expect that people do it for the love, and certainly not for the money. These people are not getting paid a lot for what they're doing. But it was seeing like the hardships that they go through, and particularly with respect to diseases. It was like a whole thing, like, how you're not really a National Geographic photographer until you've had malaria X number of times. And like they'd get together and exchange their war stories about like the obscure parasites that they'd picked up and stuff. It was horrifying. It was not good. That kind of put me right off that. So not so interested in being the National Geographic photographer anymore, but I still like living my life a little bit in the style of a National Geographic photographer, and being able to see these, just amazing, majestic natural places, and to try to capture some of that feeling of what it's like to be there in the photographic medium. Sometimes I think I pull it off. Lots of times you don't, but that's just the nature of photography and probably art in general. Try a lot of things, and hopefully sometimes it works. All right, guys, I'm going to go ahead and check out now. Got to start my walk over to town and get some details about my trek for tomorrow, pick up my bag and all that type of thing. So really appreciated you all joining me. enjoyed all of your comments and your help, like, you know, with what's going on with some of this stuff. When I have questions, that's one of the things I love about the chat. I can just ask you guys, does the USB have a log? And like, there will be people here that will know if that's available or not. So very, very cool stuff. One more, you're just not going to let me go, are you? MLC, have some factoritas on me. Churros con dulce, dulce de leche. Yes, I would love to do that. Okay. Manjaro. Manjaro in Chile, it's like caramel, and you can get it in a big bag. Like you can get a bag, like pounds. And it's a lot like dulce de leche. So that's what made me think of it. But with churros, oh, that sounds amazing. And to start a remarkable paper pro fund. Suerte con el senderismo. Muchas gracias. Yes, it'll be wonderful. Thank you so much. I appreciate that. And I'll take lots of pictures to share. So thank you guys once again. Appreciate all of you. Appreciate the mods. Appreciate the chat. Appreciate the great conversations and the good community. I love getting comments like that about it being a big hug here. It's definitely the goal is to make all this just a little bit easier to understand, a little bit better, a little bit more accessible, and a little bit more friendly. So appreciate all of you being a part of that. I won't be gone for that long, guys. I promise I'll find a reason to check back in soon. So keep posted, and I'll let you know when the next one is coming up. And in the meantime, thank you, be well, and I'll see you on the other side of this trek.